disjointed this morning. Good morning.
Good morning.
We'll bring you in about 3 minutes from now. I don't know that the defendant's going to show up, but thank you for being here in a timely manner. We'll just stay right where you are. Here's the alleged Andrew Rognus. Good minute after, at 4 a.m. with a lot of lightning, but I think you guys will be fine. So
yeah, I think so too.
Judge Stutzman's going to give me a ride out there, so I'll see you guys at noon.
Okay. Is Paul staying?
I think so.
Okay. How are you getting back home?
I don't know. I don't know. Maybe a long walk.
Sweet hitchhiker.
We'll see. My car's supposed to be done this afternoon. Are you IRLK Properties?
I am.
Yes, okay.
And if Nate Osborne comes in, he's the owner.
Okay.
And this is a termination. There's no money on this one. And I do have personal service, so.
I see that. Our next case points out how hard it is to be a landlord. And sometimes it's a lot more trouble than it's worth. Need to let the
Yeah, I
clock.
don't think I'm gonna do it anymore after this. I think I learned my lesson.
All right. It is hard. And, even our professional landlords like the Richmonds and others, they don't have a very big margin. And when property is severely damaged or there's substantial delinquent rent, but this one is going to be difficult. All right, it is 8:45. I'm going to call the matter of Brittany Busher versus Amy Dutka. It's a property at 228 South Dean Street, Centerville. We determined last week that through June, rent was $4,200 in arrears. Utilities were $221.71, $156 in costs. So through June, rent would be $4,577.71 with costs and utilities. Is that still correct?
So I did get the June utility bill, if you want to add that in.
All right. How much is that?
$59.68.
Plus 59.68. Let's make sure they're not here. Good morning. Start our landlord tenant docket. Looking for Amy Dutka or Kyle Wergau. All right, thanks. Bye. They're not here. All right, let's add that up again. Rent is through June. $4,200. Nope. According to Deputy Tyler, they're not here, and they weren't here last time either. Utilities are $221.71, 221.71 plus 59.68 is 281.39. And the court costs are $156. That equals $4,637.39. It's due 10 days from today, which will actually take us into July. But I'm not allowed to add July's rent because it's not due yet. So 7 days from today is July 7th, which is the Monday after the 4th of July holiday. On or after that date, you can come to the courthouse with $15 and ask for a writ of eviction. Sergeant Morse or other sheriff's agents would then execute it. Do you believe they're still there?
I've seen the vehicle there.
I drive past it. I haven't frankly looked. Do you miss the hustle and bustle here at the courthouse? Or
Do sometimes. I mean, the stuff that you do there is pretty fascinating.
well, that's one word for it. Some days it's fascinating, some days are diamonds, some days are rocks.
I do really like Commission on Aging, though. There's a lot less stress here, for sure.
Yes, I'm eligible for all those services, but I don't somehow. Yes. All right. Anyway, I'm sorry you're in this circumstance. It's going to be difficult for you to ever collect this money. Let's talk about that. If they don't move, you can ask for a writ of eviction. They're supposed to send you their forwarding address and in writing and turn in the keys within 4 days of their moving. You can apply their security deposit to any unpaid rent, utilities, or damages. If you wish to sue her for other damages, you can file a claim in small claims court for up to $7,500. But it may be easiest to just get them out. There are children there too, is that correct?
My understanding is that she does have 2 children, but that she doesn't have
Oh, they don't live
custody.
there. Okay. All right. Well, anyway, we'll send you this. Good luck. I'll see you next Thursday. And I won't see you next Thursday. We're not meeting that day. But anyway, I'll see you in the future. Good luck. And I signed your order.
All right. Thank you so much.
She worked in the probate family court for a number of years. She transferred over to Commission on Aging, still a county employee, but as she said, less stressful.
Hey, got a quick question.
All right.
Keely Beam at our last meeting said, hey, maybe it's not feasible to meet every month and stuff like that for the bar. I don't know, every quarter, maybe every once.
Well, that's possible. We may discuss that at the meeting today.
Yeah.
At noon, but the wheels have sort of fallen off. The announcement here, you heard it here first. The incoming Secretary Treasurer of the Bar Association will be Jacob Porter of the Hass Kaywood Law Firm. So the bar president will be Ross Truckee. The president-elect will be Mr. Keith Stickley. And the treasurer secretary will be Jacob Porter. When I retire, Judge Pattison gets inherits this
They'll be
privilege.
$9,200 behind.
Nate,
Yeah,
quiet there.
I muted his mic.
There you go.
Oh, people that don't do Zoom, which is most people. I just assumed the AR stood for Andrew Rognus.
Yeah,
I thought you wanted to get in the landlord-tenant business.
it's all on Nate's kids' initials.
All right, I did that case at 8:45 to accommodate Ms. Busher. So we started a little early and then we hit the ground running here every 10 minutes. We got 8 minutes of dead air here. This contract ran from 10 December 23 to December 24 and it's become month to month since that time.
And at this point in time, their electricity shut off because they haven't paid the utilities.
All right, it's
And
week to week.
they're using a generator.
Oh, boy. Well, let's wait till I get here. Where are you, sir? It looks like Bolin Tire.
Oh, Nate's Auto,
It's auto. Okay, where's that?
White Pigeon.
All right. Well, it's your shop. You can do whatever you want right out in the front office. So we'll be done with this here in a couple of minutes. Here's iPhone, which may be them.
There you go.
You gonna shut that door?
Yeah, but remember, if you can't hear you, let them know about your hearing aids, okay?
Okay.
Good morning. Are you Amanda Armour?
Am I who?
What's your name?
Christine Beardsley.
All right, you're a little early, but that's all right. Let me give you a proper name. You're the landlord in that case.
Yes.
All right, stick with us. I'm gonna mute your mic. Don't go away. We're waiting for the clock to tick to 9 o'clock to start our next case. Ms. Beardsley is a plaintiff in the 920 case.
Power didn't go out at the lake, did it?
Not at my house.
It did out of Omina. Gray Lake and Omina.
We had lots of lightning, not much wind.
We had tons and tons and tons of rain.
Yeah, that's okay. I don't mind when it rains in the middle of the night.
Saves the lawn.
Yeah, except you have to mow your lawn twice a week.
Well, you don't have
I guess.
to.
Makes my life a lot.
Amish to come bring their balers over.
Yeah.
I gotta check and see if Steve and Diane are gone. I probably should run over and knock their lawn out too.
They're not gone yet.
Oh,
So I think maybe next week or soon.
I just saw that their recycling toter was sitting out front and had been out there all day, so I rolled around back, so it didn't look like nobody was home.
All right, Miss Beardsley is moving around, making me dizzy.
Hmm.
8:57.
You see that Nate and I use the same barber.
Good. You are correct. You have personal service in your case. This is a week-to-week tenancy. I wrote month-to-month. I figure when I do retire, all this dead air will add up to about a year's worth of my life.
That you'll never get back.
I'll never get back. No, I would be 101. If it weren't for that, I'll only make it to 100.
And you should have a blank judgment form
I
email.
do, and I appreciate that. I don't know who that is on the wall. If that's Usain Bolt. If you go to Jamaica, you see Usain Bolt's picture all over the place. Okay. Let's call this one. And it's entitled ARLK LLC versus Donald Rhodes and Nicole Ray. And here's Donald Rhodes. Right exactly at 9 o'clock. Miss Beardsley, I'm going to put you in the waiting room. Your phone keeps bouncing. It's making me dizzy. Good morning, Mr. Rhodes. Can you hear me? Then I lose part of my life doing this, trying to get people connected. That's 2 years worth. Let me unmute his phone. Mr. Rhodes, can you hear me?
Yes, this is Nicole Rhodes. He's at work.
All right. So you're Nicole. Do you go by Rhodes or Ray?
Rhodes, it just got legally changed like a week or two ago.
All right. The title of this case is ARLK LLC versus Donald Rhodes and Nicole Ray, now known as Nicole Rhodes. Your landlord wants you to move. He has filed what's called a termination of tenancy. And as a defendant in such a case, you have the following legal rights. You have the right to hire an attorney in this matter. If you cannot pay for one, the court can provide information about how to contact legal aid, or you can seek other legal services. Usually legal aid is here, and she's not here yet, so I'm not sure if she's otherwise committed. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. You have a right in front of a trial, in front of the judge or a jury. If you do want a jury trial, you must tell the court at this first court appearance or make the demand in writing within 5 days using the jury demand form, and be prepared to pay the $50 jury demand fee and use the court form for that purpose. You can ask the judge to waive the fee if you're financially unable to afford it. You may be able to reach an agreement with the landlord by going through mediation through a local coordinated dispute resolution program. That has never happened yet, but if sometime both parties are interested in it, the court can help set that up. You may be able to reach an agreement with the landlord that means the case will get dismissed. The court must assist you in preparing that form, or the attorney could prepare what's called a conditional order of dismissal. Your landlord served a notice to quit on you quite some time ago, asking you to move. You have a week-to-week tenancy. I think there's probably a delinquency in the rent. But at this point, they're not asking for back rent. They just want you to move. Before you logged in, Mr. Rognes told me that the electricity is turned off and they're using a generator to power the house. Is that correct?
We're not there. We're currently staying somewhere else.
Well, if they're out, Your Honor, maybe we can resolve this yet today.
Yeah, I'm gonna ask, do you have any objection to them taking possession of the premises?
No, I only asked that we have like 2 weeks or so, just so I can finish getting everything out and make sure it's all cleaned up and we don't leave a huge mess or anything like that.
The law would give you 10 days from today, which would be July 7th. Would you agree to vacate by July 7th?
July 7th. Yeah, that's fine. I just need time to make sure I clean everything up and get everything out.
All right, Donald isn't here. He's subject to default. And in your case, I'll show a consent that you agree to move by July 7th. That's 10 days from today. That's the Monday after the holiday. No money judgment is entered at this time. You also have until July 7th to appeal this. Now, in light of the fact that you're not represented by an attorney and we've just agreed with a consent, the court has to explain to you that you do have a right to change your mind in this regard within 3 business days if you didn't understand what you were doing or you didn't agree with it. But at this point, we've agreed we won't have another hearing. You'll simply move within 10 days and
Yes.
Donald isn't here. Now, let me tell you some other things. When you move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving out. That will trigger the security deposit law. Your property owner can apply your security deposit to any unpaid rent or other damages. If he wishes to seek other damage, he can file a further hearing regarding money damages, but this is possession only. So I'm not ordering you to pay anything. I'm just ordering that you move.
Yes, sir.
Judge, may I ask or say something?
Yes.
So we did a inspection 2 days ago, and if they're not living there, can I ask that the dogs be removed that were not previously approved? They were not supposed to have animals, and there's 2 dogs in there.
Is that true?
Yeah, we've always had the dogs. They're the same dogs
But-
that we talked about before we moved in and when we did move in.
And
I think that the
they're-
lease says no dogs, but anyway, it's hot. So you got dogs there. I would suggest you remove those as soon as you can. Anyway, you, everything have to be out by July 7th or you're subject to being evicted.
Yes, sir.
All right, what kind of dogs are they?
She's a pug and a chihuahua, and then a pit bull.
Of course, it's a pit bull. It's always a pit bull.
She's not really a pit bull. She's more like a chihuahua too, but yes, a pit bull.
All right. Anyway, my suggestion is, here's Ms. Bauer. She's here live and in person. All right, Ms. Ray, good luck to you.
Thank you so much.
Stay in contact with your landlord. Remember, you have to turn in the keys and give your forwarding address within 4 days of your moving.
Okay.
All right, thank you.
Thank you.
All right, so that takes care of your case. Andy, I've signed your judgment.
Okay, thank you.
Pit bull chihuahua. I don't know about that, but anyway, it's always a pit bull. You coerced Meg into coming down here for golf, so I guess she figured she might as well be in for a penny, in for a pound. She's here live. All right.
See you soon, Andy.
All right, you're good to go.
Okay,
Thank you. Sir. All right, thank you, Andrew. I'll see you at lunch. All right, let's bring in our next people. Fairly smooth sailing so far. You're fine. Good morning, Miss Beardsley. We're back. And also, are you Amanda Armour?
I am.
All right, let me give you a proper name. Miss Beardsley, your case is 9:20. Miss Armour's is at 9:15. So we're waiting for the bank to come in. But while we're waiting, Miss Armour, I'm going to go ahead and advise you of your rights as a tenant. You have the right to hire an attorney. If you cannot pay for one, you must, we can give you information about how to contact legal aid. And there is an attorney here from legal aid today. You have the right to have your case heard here in St. Joseph County where the property is located. You have the right to demand a jury trial. If you want a jury trial, you must tell the court at the first court appearance or make the demand in writing within 5 days of the hearing. If you wish to have a jury trial, you must make that demand or file the form within 5 days and be prepared to pay the $50 jury demand fee. Your landlord has asked you to move. This is a termination of tenancy and a mortgage foreclosure action. You may be able to reach an agreement with the bank by going through mediation, and if both parties are interested, I can accommodate that. You may be able to reach an agreement with the landlord that means the case would be dismissed. The court must provide you with a form for this or tell you where to find it online. Now, this is a court proceeding, and it looks like you're sitting in bed, and it looks like you're dressed for the beach rather than court.
I'm actually in a very nice dress, and I'm sitting in my living room.
Okay. All right. I'm no fashion expert, but okay. The bank should be here in a couple of minutes. This is set for 9:15. It's 9:10. So we'll let the clock tick here for a bit.
I apologize if my attire was not appropriate. If this,
Thank you. That's helpful.
okay, I apologize.
Well, we know one thing for sure. He's lying. Because by the time the change to try and picture something that hasn't happened yet, this change requires suffering and pain.
Good morning.
And sacrifice.
Oh, good morning.
Most men
You've got something going on there, a television or something.
Yeah, I'll turn that off. I just
Please.
joined, I joined the meeting for Jack, I think a little bit early. I think it's at
What's your name?
9:30. My name's Karen Moore.
All right.
So, yeah, Jack doesn't have anything to do with Bum Whitson's he doesn't live there. He had Bum working for him for a little while, and things just did not work out. But I think Larry's evicted him 2 or 3 or 4 different times.
All right, we'll come to that in a bit.
Okay, so
All right.
you want me-
just stick-
you want me to
Yeah,
get Jack?
Yes.
Okay, so he's down at the shop right now, but I'll run down and get him. I think he's gonna be up here at 9:30. But if you're
All right,
ready
I'll-
to hear
No,
everything.
I'm not ready. You'll be fine. I'll put you in the waiting room.
Judge, I just gave Elaine an appearance in 10, I think it's 1040 case.
Who's that on?
That's Amanda Boyer and Alan Kressauer.
At Riverside?
Yeah, the mobile home prayer.
Oh, Riverside Estates. Yes, okay. You didn't end up in the Courtney Schwartz case?
I didn't get any contact.
All right.
Just to make sure. Last night I was thinking, or yesterday, I was thinking, I thought there were 2 consults from last week. I couldn't remember the other. I read it down.
Oops, wrong month. 11. What's that? There is a criminal arraignment on my docket for Friday, July 11th. Gabriel Villafuerte Ramirez. I don't think that belongs on there. I think it belongs on Judge Patterson's docket. No, that's right. It's my attorney pretrial day. That's correct. Sorry about that. Yeah, that's my first Friday of the month. That's gonna be very busy. So pretrial or landlord tenant that day will be in the afternoon. All right, it looks like Mr. Chevernak is here on behalf of Trot and Trot, and we can start Miss Armour's case. Good morning.
Good morning, Your Honor.
I'm gonna call your case. This is Fifth Third Bank versus Amanda Lynn Armour and any other occupants at 111 West Kelsey Street, Three Rivers. It is a mortgage foreclosure action. The mortgage sale was actually last October. Ms. Armour is here. I took the opportunity to advise her of her rights as a tenant because she was here a little early. Mr. Timothy Chevernak is here from the Trot and Trot Law Firm on behalf of the bank. Their mortgage was foreclosed on. The bank wishes to take the property back. Ms. Armour, what's your position?
I was unaware that I know that the mortgage foreclosure sale was being held, but I was not notified that the sale was completed or the sale was successful. So I was unaware of the 6 month, I believe it is, stay in between the mortgage foreclosure sale and the, I don't know how to explain the,
Well, they put you notice that there was a sale, and in the notice, it says you've got 180 days to either redeem it or move, and you didn't do either one. So it's now been 8 months, and they want you to move. It
Mhm.
doesn't look like you've started any of that process. What's your position?
I have been looking for places. I know probably you know better than anyone that there's not, there's really nowhere to go right now. I'm on several waiting lists for several different apartment complexes. I have contacted the private landlords. I have looked outside of the county, I've looked outside of the state. I actually have a house I'm going to see today in Shipshawana. So it's not like I'm not trying.
All right, well, this is the process where it really just forces the issue. You probably haven't made a payment in a year or two, so right now you have the benefit of no house payment. And certainly since the foreclosure action, since October, you've made no payment, so your rent is zero, except for the utilities. But what happens is, instead of, you'd think people would have a big pile of money because they haven't paid rent in 2 years or made a house payment. They don't.
I
They
do
spend
though.
money. Oh, well, all right, so you have money, all right,
I have
but,
a substantial payment and I'm on, like, I have several $1,000s
Okay.
that I have told several landlords and apartment complexes, I will put this toward, the first 6 months of rent. I have several $1,000s.
do you have a dog?
No,
All right, that often makes it hard to move if people have pets.
I have 3
All right,
kids.
3 cats, all right,
No,
well,
three kids, not 3
3
kids.
kids, right, okay, well, like I said, this forces the issue. The piece of information you do need to know is you're entitled to adjourn this matter at least 7 days, which takes us to next Friday, July 11th. So I'm going to continue this.
Just to clarify, Your Honor, next Friday would be the 4th. Is it the 11th due to the holiday?
That's right. The 4th is a holiday, so we could go to Monday, the 7th. At 2 p.m.
Okay.
Does that work for you?
Yes, Your Honor, that works for us.
Yeah, 2 p.m. would be
All
fine.
right, now, this Armor, you then get 10 days from that day to vacate. So that would be July 17th, and after that date, the bank could ask for a writ of eviction to put you out. They don't have to put you out. They have 56 days from the day to ask for the writ of eviction. But like I said, the rent's probably been unpaid, or the payment's been unpaid probably through all of 2024 and probably back into 23, but certainly no payment since October of 24. So they would like to get the house back, prepare it for sale and start over again. So we will meet again by Zoom like this a week from Monday. That'll be July 7th.
Okay.
At 2 p.m. Do you have any questions?
So, at that date, you said I would have 10 days from that
10
day.
days from that day to move, which would be to July 11th, which is a Friday. So as a practical matter, probably the first day they could actually seek the eviction would be 7 to the 17th. Yeah, you'd have till July 17th.
Before
And the Friday. So
then
they could give you more time if there's a plan to move out. Mr. Chevernak's number is on the pleadings that you've received. His law firm Trot does lots of these all over the state.
Okay.
And no two cases are exactly alike, but there are similarities and the same law applies. So it's taken them from October to now to get to this point. Now you get 7 more days and then you get 10 more days. So it takes a while, but we'll revisit this on Monday, July 7th at 2:00.
Okay, I can do
All
that.
right. Thank you, Mr. Chevernak. Anything to add?
No, Your Honor, thank you.
All right, I'll see you on Monday the 7th.
Okay, thank you.
Good luck, Ms. Armour.
Thank you so much.
All right, Ms. Beardley is set for 9:20. Let's call her case. I'll unmute her microphone. Good morning. Are you Christine Beardsley?
Yes, I am.
And you're asking to remove Autumn Beardsley and Anthony Beardsley, is that correct?
Yes.
Now, you all live in the same house at 68338 Lutz Road. Are they still there?
Yes.
Who are they to you?
It's my grandson and his wife. And they have 2 small children.
There is no lease
No,
and they're not paying any rent.
no.
In addition, I think this is the one where he brought all kinds of junk to your property too.
He brought a truck and he removed it. He did remove it just a couple days ago.
But the cops been here like every other, like a couple times a week.
Yeah, and the police have been here frequently, like they were just here last night with an argument, a fight.
Where are they right now?
They're in bed. They don't get up until noon.
Oh, boy.
You shake, so I don't know. Tell me you got Parkinson's and you shake, so that's what I told him.
Well, I'm gonna default them. They both personally served. They have 10 days to move out, or you can ask the sheriff to throw them out. Where are their kids? They all sleep till noon?
They all sleep in one room. The kids he won't let out
Does he want me to knock on the door?
because
He won't
he
let me.
uses them over our head. Do you want her to wake him up?
No, if he's not ambitious enough to get out of bed for a court hearing, he can suffer the default. I find for the plaintiff that they have 10 days to move, which would be July 7th.
At midnight?
July 7th
Now-
at midnight?
Yes, at the next day, July 8th, you can come to the court and the sheriff, you come to the court with $15 and you ask what's called a writ of eviction. That's when the sheriff physically puts them out. Have they made any effort to vacate?
No. His mom and I have called around even for him, and they missed out on a couple places.
Autumn's lazy. They have an open CPS case too.
But who's with, is that who's with you, his mother?
No,
My daughter,
All right, that's his aunt.
no, her husband.
that's his mom. They've been here since February of 20, was it 21? 4.5 years they've been here. He's not worked only a couple months.
All right, well, you're carrying his freight. He needs to get out of bed and take care of his own. He needs to get out of bed and
Yeah,
grab a hammer and a nail. Anyway, I don't have much sympathy for them. I have sympathy for their kids.
They have an open CPS case.
yeah,
They have an open CPS case.
Yes, they do.
yes.
Katie Johnson. She's
All right.
actually got
Katie
probation.
Johnson is the worker.
Yes.
Yes.
see if I can get a copy of this judgment to her. They have until July 7th to move, or you can have the sheriff throw them all out
On the 8th.
On the 8th.
on the 8th. Yep.
Okay.
All right. Thank you. This is the way you do it. You can't just throw their stuff out in the street. You have to go through the landlord-tenant process.
So on the
But,
8th.
But on the 8th, you can, now they probably won't do it immediately on the 8th, but they'll do it within the next day or two after that. So you come on the 8th with $15 and ask for the writ of eviction, and the sheriff will put them out.
So ask him.
Does he just, he just throws their stuff on the road?
Yep. He gives them a chance to move it, but if they don't, it sits out on the road. It's like a giant garage sale. People
Right.
come out and just pick through the stuff that's out there.
Yeah.
So
But you can't
it's
do
in
that,
there.
can you?
I can't do it all. It has to be a police officer?
Correct.
Okay. Yes, he said.
Okay.
All right. We'll see how this plays out. I'll try to get a copy of this to Protective Services.
Okay.
All right.
Okay. Thank
All
you.
right. Good.
Thank you.
You have a good day.
All right. I'm working on it. You too. 4.5 years of deadbeatness, not a good thing. I wish Terry would change her name, so I don't have to do it every time.
I thought you meant-
No, it's always just logged in as lowercase Larry. Oh, I have both of them today.
Yeah.
Terry, Larry, I didn't give Larry any credit on here. He's just there as a co-plaintiff.
I could use some credit.
All right, I've got Mr. Dwayne Whitson here. Seems like we did this a while ago.
Yeah.
And Jack Moore is here also.
Hello.
Good morning.
Hey, Jack.
Hi. Morning.
Hi, Jack.
Hi there.
Hi, buddy.
How's it going, bud?
It'd be better when we weren't here.
No, I hear you. I hear you.
Yeah, we'd all be better if we weren't here, but we are here. So
Here we are.
this is Terry and Larry Richmond versus Dwayne Whitson and Jack Moore. I think Jack Moore is more of a co-signer than a tenant.
Yes.
This is a landlord-tenant proceeding. We went through this a few months ago. The case number here is 251284. I would also note that Megan Bauer is here from Legal Aid in the courtroom, available if she's needed for a consultation. Mr. Whitson and Mr. Moore, you have the right, or as a defendant on landlord-tenant proceeding, including this one, which is a termination of tenancy. At this point, they're simply asking you to move.
Yeah.
You have the following legal rights. You have the right to obtain counsel for representation in this matter. If you're cannot afford an attorney, a legal aid attorney may be available to help you, or you can seek other assistance. And as mentioned, a representative from legal aid is here in the courtroom. You have a right to have the case heard here in St. Joseph County, where the property is located. That's never been an issue, not even once. What we got here? This is the Talberts. Ms. Talbert, can you hear me?
Yes, I can hear you.
Is Wayne there with you?
No, he had to end up having to work.
All right, well then, let me go through this with you also. This is a landlord-tenant proceeding. In your case, it's a demand for non-payment of rent. If you can and afford to hire an attorney, if you wish to have one, a legal aid attorney could be available to assist you. You have a right to have the case heard here in St. Joseph County where the property is located. Your landlord has asked you to be evicted in Mr. Whitson's case because they want you to move. In Ms. Talbert's case, they want you to either pay the rent or move. In the case of non-payment of rent, you may be able to get assistance from the Michigan Department of Health and Human Services, local coordinated agency, which is Community Action Agency, Housing Assessment and Resource Agency, which in our case is Neighborhoods, Inc., or federal help for homeless veterans if you're available and eligible for veteran services. We sent that information to you with the summons that you received. You do not need a judgment against you to receive help from the places listed above, despite what the DHS might tell you. Copy of the summons and complaint are sufficient, and you've already received that. All right, no grooming on the live feed.
He had something on his face.
Reach an agreement outside of court by going through mediation. If both parties are interested, we can pursue that and I can help set it up. You may be able to reach an agreement with the landlord. That means the case would get dismissed through a conditional order of dismissal. If so, the court will assist you in preparing that form or locating it. So, Mr. Whitson, at this point, they're not asking for rent anymore. They want you to move off this railroad street property in Sturgis. They allege that you failed to maintain the property and they want you to move. Now, Mr. Moore, you don't live there. You're simply a co-signer on the lease.
I'm not, I didn't sign anything, Your Honor.
But you don't live there?
No, I never lived there. And I don't even know why my name, I haven't signed anything, Your Honor.
Why is he here?
Because
I have no idea.
Well, sign cutting with that kind of work.
Well, Miss Richmond, why is Jack Moore here?
because he was a co-signer. He was also on the lease.
No, I was not. I was on no.
Just let me look.
He didn't.
Bed bug is Whitson. Carbon monoxide is Whitson.
I wasn't here.
I don't see Jack Moore's signature on anything.
It's not.
He is on the lease, Dwayne Whitson / Jack Moore,
No.
but he did sign the lease. All right, well, Mr. Moore, stick with me.
We weren't here at the time. So Lydia did it.
Anyway, so you don't have a dog in this fight, but
I
Mr.
don't
Whitson,
know.
they want you to move. What's your position?
That's no problem, Your Honor. I mean, I failed to maintain the property because of some trash and stuff, but I was recovering from double pneumonia at the time, but I did my best to pay the rent. And I work for Jack Moore, and work's been slow and so forth, but I sold my truck, as you know, last time to catch the rent up and cut it up and gave them an extra $1,000 towards May's rent at that time, you know, that I could. And then I went to pay rent and on the 5th, I believe, of June, and Ms. Richmond Terry said that she couldn't take it because they were evicting me. So that was the first time I really heard of it. But I mean, that's no problem. I'm not trying to stay here, you know, past my will. I just need to.
How soon can you vacate?
I mean, what I would like to do is offer the Richmonds. When I moved here, guys, Larry and stuff, last year, I bought all new stainless steel appliances and so forth, stove, fridge, washer and dryer, all Whirlpool, and microwave. And if I could have till like August 1st to vacate, I'll go, no problem. And you guys can keep that. Maybe it'll help you rent the place, furnished with stove and
So
everything.
you would agree to vacate on August 1st and leave all the appliances?
Yes.
You talk, yeah.
That'll give me time to, get money and I can find an apartment or something. No hard feelings, no, didn't.
Well, Mr. and Mrs. Richmond, that would be only an additional 13 days. We have to adjourn this to the 7th of July, and then he'd get 10 days from that. So he'd get until July 17th. So by his proposal, he agrees to leave by, we'll call it July 31st,
Okay.
out by August 1st, and leave the appliances. So is that agreeable to you, Mr. Whitson?
Yes.
Mr. and Mrs. Richmond, is that agreeable to you?
Yes.
Yes.
So we
I
got.
got the sense from the last case that you guys had a fairly decent landlord-tenant relationship, but at this point, it's just what it is. So I'm going to show by consent, defendant agrees to vacate by July 31st. We'll leave all appliances in place.
Do we have to come back to court then?
No,
Okay.
you have until July 7th to appeal this. Mr. Whitson, we've just made an agreement for a consent judgment. You don't have a lawyer. So you do have the right under the law, which is MCR 4.201J, to change your mind. If you didn't understand or disagreed with what we just did, you can tell the court within 3 business days. We'd have to schedule a hearing regarding that. Otherwise, I'm going to show a consent order that you'll be out by July 31st, as opposed to July 7th or 17th. And if you vacate at that time, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving. Then you will also leave all the appliances in place.
Yep.
And the tenancy will be over. They're not at this point asking for any money damages. They're just asking for possession. If we're going to have a hearing regarding money damages, that will be at a later date. Do you agree with those terms and conditions?
Yes, Your Honor.
Do you have any questions?
No, I don't think so.
All right. You guys have good contact with each other. Stay in contact. Let them know what your intentions are. As I said, when you do move, you need to turn in your keys and give your forwarding address within 4 days of your moving. And Mr. Moore, this really doesn't have any effect on you. You don't live there. You didn't appear to sign the lease, and he's going to vacate, and you can just go on with your life as you have.
Okay, thank you, sir.
All right, you're good to go. Thank you.
Bye-bye.
Bye. All right, Mr. Whitson, you're good to go.
Okay, thank you, Your Honor. Thank you, Larry and Terry.
Oh, you're welcome. Thank you.
Yes.
That sounds like a pretty good agreement. See how those appliances are, and he gets a little extra time, and he doesn't have to move all that. And all you're giving up is 13 extra days, 14 extra days. All right, Ms. Talbert, let's talk to you. We went through the advice of rights. This is Terry and Larry Richmond versus Wayne and Leslie Talbert. Wayne is not here. Terry and Larry Richmond are here. Ms. Talbert, this case is a little different. The last case, they just wanted the guy to move out. In your case, they want you to pay the rent. And if you can't pay the rent, then you have to move. But Ms. Richmond, what's the current arrearage?
Okay, she paid some money. There was money in the office today, so her rent is only $487.02. and court costs were $199.25 for a total of $686.27 through 7/3.
All right, this is, I think, week to week through Thursdays, but you just made a payment.
Yeah.
So you're really not that far behind. Miss Talbert, do you agree with that?
Yes.
All right, well, the law says you're entitled to 1 7-day adjournment, and then you'd get 10 additional days from that day to pay. So let's take a look at where we are in 7 days. That would be July the 7th at 2:10. Does that work for you?
Paid a 6. I forgot the amount. What was the amount again? I'm sorry.
The amount is $686.27.
Okay.
Now, it's gonna change because you're gonna owe another, it's $250 per week.
Yes.
Yep.
All right, so there'll be another $250 due by July 7th. But this is through July 3rd. You owe $487.02, $199.25 in costs. I'm not gonna default Wayne because he's at work. You heard the other case, the people were bad. They didn't have enough ambition to get up to appear at their eviction hearing. But people are at work, they're trying to earn money to pay the rent, so I don't do a default.
Okay.
Ms. Talbert, let me ask just for a minute, how are you guys doing?
We're doing okay. We just figured that we'd be in a better place financially, but I had to end up having surgery, which kind of put us back. I had
I don't
surgery
want
on-
to get into your personal business, but as you know, we've
Okay.
had some cases and we got through them, and I just want to make sure you're doing okay.
Yes, sir.
All right, we'll revisit this next Monday. Now, if you've paid Monday the 7th, excuse me, not next Monday. If you paid everything, you don't even need to appear. So if you can pay everything by that date, then you'll just
July
be back.
7th.
If you can't, then we'll discuss it further and see what the arrearage is. But as I indicated, by the time we come to court, there'll be another week's rent due.
Okay.
And
All right.
what time was court on the 7th?
2:10.
2:10. Okay.
All right. Anything else we need to do here?
Nope, I don't think so. Thank you.
Thanks, Your Honor.
All right. Good luck to you. I'll see you guys in 10 days.
Okay.
Okay. Bye, Leslie.
Bye-bye.
All right. All right, Miss Richmond. You
How you doing, bro? Mark, how are you?
You're leaving now?
This is a skill that the state, I believe, is not.
Judge, this is an old colleague of mine, Mark Lambert. He represents one of the banks that Bruce Cobb has tried to subpoena records from.
Colleague
Yes.
of yours?
I don't know if that's comment on me personally or.
He's he looks fairly young, Your Honor.
Well, when y'all stand close to each other, yes. He does. Hey, Bruce, a couple of things here that jumps out at him. As you know, this thing's 4 years old.
Right.
It's too old. We gotta move forward.
Right.
So how are we gonna do that?
I'd like to get that discovery so I can defend this case.
Well,
what's
okay, so let me respond to that, Judge. If his contention is that he's going to utilize this discovery to defend this case, that is absolutely ludicrous. That it's the amount of loss is not even an issue in the indictment. There is no complainant listed in the indictment. That'll be his next thing he points out, which is that the complainant really recently passed away. So if this discovery is designed to determine the restitution and he wants to resolve this case, then yes, I'm for it. But the amount of loss simply isn't an issue. And I've always agreed to a limited version of producing this discovery under the assumption that he was trying to get it to make arguments about what the restitution should be.
Well,
But if
yeah,
he,
but it's a lot more than that,
it absolutely is not, actually.
To the fraud is an essential element.
Okay, well, how does that amount of loss have anything to do with intent to defraud? One shred of
In
evidence.
this case.
Okay, well,
But, you know, it should be very relevant to the amount of restitution, if it is.
which is not something the jury even determines.
All right, y'all through? What is it everybody wants?
Okay, Judge Mark Lambert, I'm here for Purdue Big Credit Union. I guess I'm the point of contention here. At this point, we've received a subpoena. We've objected to the subpoena for the records that Mr. Cobb are referencing. Under section 59 of the finance code, the only possible way I can produce these records for Mr. Toon, whose records are being sought, is if he is served with notice and has the opportunity to object and signs a waiver. Otherwise, the financial institution can be held responsible for releasing privileged and private information and not information. Obviously, that didn't happen. He's now passed away. The only other opportunity for Mr. Cobb and Mr. Eckert to get these records, if the court so desires and grants, is if the court will sign an order for us to provide the records to the judge for an in-camera inspection to determine the scope of the records that would be either admissible or discoverable and any redactions therefore. I don't think I can technically redact until the court says these are the records we have to produce. So we have a subpoena sitting on us that is due. I have objections that I filed with the court. I just don't know the scope of what the court will require me to produce to the party.
What do y'all say about what the gentleman just said?
Well, Mr. Kuhn was supposed to have gone and done a waiver, which we had agreed that he would sign, but he never got around to signing it because he passed away in the process. I've been a lot better than for.
We know he's passed away. What are we going to do about it? We can't change that. We move forward, and we're moving forward one way or the other. The passing away of an important person involved in a lawsuit doesn't scuttle what the grand jury has indicted. So we move forward.
Judge, I think you need to order the bank to give you the records in camera.
That seems to me the proper way that this court has control over the situation, and all the parties are placing it into the hands of the court in these pretrial matters, which I think is where it needs to be. And when there's a disagreement of the way things should be. What I want from the bank is a proposed order, please, that
probably has
fits with what you deem under the law is the way to proceed, that also is in the best interest of your client's liability exposure. And I can appreciate, my dad was a battler, so I will appreciate the caution. But this is 4 years old. It's way too old.
We had worked on an order. And I think
I have a motion to compel discovery here back in January, from January, and then an order granting a protective order here. This was this presented by?
I think it was a mutual document drafted by Mr. Cobb and I initially to protect us until he could get the waiver signed by Mr. Toon. And I think at the end of that order, if I remember correctly, is the section 59. And it sets forth the documents that he wanted and that we would be protected.
Have you seen this?
I believe I have.
Any objections for me signing this?
What's the scope of what's to be produced?
It's that same thing that I mentioned.
Well, Bruce,
when you do it, it bothers him.
yeah, because it's way broader than what we talk about.
He's always grabbing for his wallet when you're near him, Bruce, for some reason.
Just so we're on the same page, Your Honor, we're talking about a lot of records. They haven't been sifted through by the bank because we didn't know the scope. So I can narrow it down to whatever scope that the court orders or the parties agree on. I just need some guidance.
Yes, this number 2 here is the scope of what I've agreed to obtain for them.
I've got both Mr. Coker and Mr. Cobb's signature on this.
Sure.
Okay, that will be made a part of the record, and we have a defendant's motion to compel discovery and request for hearing this. What else? Go ahead. It's moot.
We already had.
You withdraw this then?
Yes.
Okay, then. So what's next on this 4.5-year-old case to move it forward? What do we?
They're going to submit an order.
Yeah.
Okay.
Yeah.
All right.
They've yet to tell me.
May not work depending upon what's going to be necessary for preparation, but it'll stay there on that docket, and it'll be at least a goal for us to reach.
Right.
To try to reach. What else do we need to do today that you need from me?
I think that's about it, Your Honor.
Okay. From the state, how many witnesses are you guessing you're thinking about? And maybe
5 to 10.
Okay.
5 to 10.
All right. Anything else? No, they can't. Then we'll see you back in August, I guess. Try to do what you can to be ready.
And the documents will be submitted to the court,
Absolutely. We'll submit an order to Ms. Records, Ms. Cobb, and have that to them this afternoon. I can have the records to them next or to you. Next
While we got this.
Yes.
So I'm not in the dark.
Uh-huh.
That's because I don't know, I don't know anything about the facts of this case. I can look at the probable cause and that's all I can see. What is it that each of the parties are asking me to be wary of and to pay attention to?
Well, for one thing, I think they're going to have this co-defendant testify, and I'm going to have to probably.
No, I'm talking about the records.
Or the records?
Yeah, I'm not talking about that. I'm talking about the records.
Outside of the property deck.
I'm going to get a bunch of records here.
Yeah.
And I want to be able to sift through what's relevant for me to look at and what I don't need to spend the time looking at.
Well,
what's the defense?
Part of the thing that we are contending is that this was a normal construction. Somehow this was a construction case that went awry, and the complaining witnesses stopped the work, which is rare. The normal case would be like a roofer. When you give $20,000 to a roofer and he starts to work on it and he doesn't complete the job and he runs off. This isn't the case at all. These people worked on the job until fired. They were fired by the Coons. For some reason, the Coons also sold it, did a sub sale, and also had debt forgiven by the do good. And what this does is it pretty much cleans it up. There was no intent to defraud ever.
I'm not asking for your final argument. I'm just asking for what is it that I need to be paying attention to. Your view in these gigantic.
I need to find out if the Coons ever put some money up front that was never
records.
In the records.
What is it in the records I need to be looking at?
Well, that's just partly it. But the thing about it is how the do-good controlled the draws and gave the money to Mr. Coon. And Mr. Coon was the one that gave it to the co-defendant. And then the defendant actually had him, supervise the work on the job.
Okay.
That's what it is. This should have been a civil case. And Your Honor, there's one other
Okay,
thing.
the grand jury thought otherwise. That's the way it
I don't
is.
think the grand jury ever saw that there was a $1 million.
You were in the grand jury
negligence
room?
bond.
That would have been an illegal act.
No, I
You don't
wouldn't
know, Bruce. Can't talk for them.
Even
And
so.
you trust that they're gonna abide by their oaths. And until you tell me otherwise, don't badmouth the grand jury.
No, Your Honor, but this is a
Don't
complicated
criticize
case.
the way that this is done unless you have something to say about that's articulated. They came up with an indictment, and I know grand juries, from my experience, they don't dream it up. And it's probable cause. This is beyond a reasonable doubt. That's the big difference. But don't be arguing, a grand jury indictment. It's there. So we're dealing with it and we got to move forward with it. That's a waste of time. Unless you can say that the grand jury did something wrong, which I've never had that presented to me in 44 years. Okay, from state.
I would urge you to go through the redactions with a heavy hand because it is virtually pointless. What he's describing is nothing that is relevant to this indictment of whether or not this man misapplied trust funds. The only reason I've even agreed to this is because it's taken him a year and a half to get this.
Okay, well, we're fast tracking. You got my attention, which is going to move this case forward. From the third part.
How would you like them? I can do them in paper form, digital, zip drive, whatever the court prefers, and it is easiest for you to review. And representation.
Well, everybody's going to get the copy of this.
Once you've had your, just like with CPS records, Judge, you have to decide what is redacted first. And I will say for the record that typically when CPS like this, CPS often produces records in camera like this for this court to review. They submit proposed redactions.
Okay.
With their records. I understand that may take you longer. However, that often is what the court looks at and relies on.
Okay.
Just so you know.
Well, I guess hard copy is easy to. Nowadays, I really don't know. I'm just used to hard copies.
You're talking about thousands of pages, though.
Judge, how about I do both? Hard copy and zip drive. Would that
Okay.
be easier?
Yeah, because I can pass on those to the parties. It's easier without getting a pickup truck. Okay, let's see what we can do quickly, and then we've got an August trial date.
Thank you, Judge.
Thank you.
Thanks, Judge.
We'll be here.
You've got Roberto Mears.
Yes. Who's the next one? Well, yeah, but I need to see, I need to see.
What about him? Where is? What are we doing today?
Motion to withdraw the Irish counsel.
Why?
Well, for one thing, he's not gonna pay me anymore, I don't think. At all. I've been without pay for a number of months. And we're supposed to be coming up to trial.
When is this trial set? When was this on? Please, June 2nd? No, that was the last.
That was the last
event.
day. I don't think he had the present setting. I know of.
Yeah.
And we had hearings.
Setting for the hearing, it's got to be raised.
Yeah, we had, the last trial setting was in March, Judge.
And this is this is 2.5 years old, and now we're not getting paid.
Yeah, I just worked with him, tried to get payment, and now he doesn't pay. He hasn't paid for several months. I'm not sure what his problem is. He never talked to me about it.
I don't get involved in this, but is there a problem?
Yes, very much so.
What is it?
It's black and white. None of the things that I've asked him to do have been done. There's no motions on my end. We're here, we're at 2.5 years later, as you said it yourself. I mean, it shouldn't be going to trial. So waste of money for the state. So waste of money for myself and time. It's all started with the police investigation. I've never talked to police once. You know, I've never talked to this man to be able to talk to him, to get through the state and say, hey, this doesn't need to get to escalate. We need to save the state some money.
I don't, that's wonderful. He should know this is an aggravated assault. Case. Either assaulted a guy or, you know, he was self-defense.
When did you get hired, please?
I got paperwork stating that he was retained May the 24th.
May the 24th.
Of what?
2023.
Okay, 2 years.
2 years.
So 2 full years goes by and now you're filing a motion to withdraw because he hadn't paid you?
In a while. You know, I think the last time he paid me was before December.
Right.
He thinks probably he paid me too much. I don't know. I don't know what the heck he's talking about as far as motions. He wants to talk to the police. You know, he doesn't have the right to talk to the police. And it's kind of, if he asked me more fundamental questions, maybe I could explain it to him. Now I've got expenses. I've got to travel. He's known since December that I've been moving to Longview. And it would cost me some money to come down here and try a case. So I was just trying to get the last, it's going to be 3-day trial.
Mm-hmm.
And he needs to at least pay me for the 3 days of my expenses.
It's also been my experience that sometimes you end up getting stuck as an attorney. Then it's not a good deal. It happened to me when I was in private practice. You get stuck, and there are legal ways of handling that. But what disturbs me is this has gone 2.5 years, and now I'm looking at I'm being presented with something that is far overdue for trial, and y'all are bickering over a civil contract that isn't being worked out.
Well,
That's not for the court to resolve. It's not for the court to resolve. You got a problem with him? There's a bar. There are agreements that you can file.
I completely agree.
If that's what you want to do, if you assume a responsibility to represent it, and that you can't do 2.5 years really, and then whatever money has been paid, I don't know. I don't want to get into that, but some money had to have been paid.
Yes.
And this is overdue for disposition. And what we're going to, 2 things. I can release you, then we have to start over with another lawyer. And that would be fair to the people, which is my first responsibility, as well as the constitutional rights of defendants. But moving a trial forward without unreasonable delay is foremost. And I don't get these problems. These are always worked out. But I also know lawyers end up losing money on some cases. It's a responsibility, though, that they deal with. If you're indigent, are you indigent? Are you able to pay? Do you have a job?
No, I beforehand, I did have a job. Now circumstances have changed. I don't have a job. I haven't had a job for the past 5.5 months. I'm working on getting a job. This is delaying on me getting a job.
So you don't have an income right now?
No, I do not have an income.
All right.
I didn't understand. I didn't know that.
All right.
Either fully. I know I gave him a little time because you should find jobs.
He can
easy.
Look.
Okay.
You.
But the thing,
you can continue to First of all, you've spent the time. You've gone down the road on this. I'm not going to start over. If you come to me later and apply for indigent funds to help you in this case, I'm happy to consider it.
Sure.
And it doesn't happen often, but it's happened before, and those have been granted. Reasonable fees have been granted, but I want your 2.5 years and yours. Y'all fix this together, work together. Please, it's in your best interest, in your best interest.
Oh, definitely.
I didn't know I could apply for.
It's, well, it doesn't happen
Right.
normally, but there's always an answer to every unique situation that this court over 18 and a half years has had to deal with. But we just don't open the door for the people to pay. Y'all work it out. But if his situation has changed and he's unable to pay, then he needs to fill out an indigent form before he leaves, so that can get into the record. If it changes, you have to let me know, or else you're in trouble. You get a job, fine. You take, start accounting for your time that you would ask for reimbursement for while he is indigent. But this moves forward, please. Well, I'm going to be kind about it. I'm demanding, I'm ordering it to move forward. Y'all had enough time to prepare, get to the finish line one way or the other, however this is going to be disposed of. Okay? Is it Mr. Ham on this one?
Yes, sir.
This doesn't look like a real complex matter. It could be, but
I've got it whittled down to 3 witnesses, Judge.
Yeah.
there's no reason to delay 2.5 years on 3 witnesses. Come on. No, y'all's business is yours, but the state, it's succinct. It's obvious.
The only thing that is the 2 of my witnesses will require an interpreter.
Okay. All right. And if it's not going to be disposed of by a trial, let me know so we don't spend time and money preparing for a trial. If it can be worked out, let me know. If not, let's try it. But what's it set for, Helen?
I can put it on the 25th when Mr. Cobb is here already. That would be.
No, he's not going to be ready. I'm going to give me another month, please. We're setting this, y'all, that's the finish line.
The 22nd September.
Okay. That's.
22.
All right, that's set on that day.
We'll make sure.
We'll work together.
Correct. If I may say, one of the things that I want to bring up, obviously that was a sideline for me from the get-go. I wanted to bring up, I also want to get this over with and situated, which I'm willing to talk to Mr. Croft, see if we can continue this, because in reality today, I got started with this paperwork on the 24th of just the other day, saying, this motion for him to get out.
Yeah.
But we realized this before in our previous time that we came here, when he didn't show that he wasn't going to no longer be able to partake in this. I came here on my last continuance. I was never even called up here. I showed up in the morning. I was on the court docket online. No one gave me an explanation. I just waited for the bond people to call me. I mean, I don't know how it slips through the cracks or who gets, but at the end of the day, I'm here.
Trying to close that.
Look, when motions are presented, when motions are filed, that doesn't get my attention because I've got 2,500 cases, 2,500 cases. So lawyers know they can file a motion, but I'm not going to even know about it unless it's presented. We call it presented. They've got to present it to me, get my attention, and get everybody together, and then I will conduct a hearing on it. The fact that it's filed, that doesn't get to the finish line. You have to present it, and then we'll take it up. It would be enormous. And most motions, strangely enough, are never presented. They file them, and they sit in the file, and then they get shredded at the end because nothing was ever done about it. Nobody ever presented. Nobody ever moved on it. They filed it. It seems to me a waste of effort, but until it's moved by the parties, one party presents it to me, we have a motion, we want to have a hearing on it, and then I'll do it. Because most motions they're filed and then they're never moved on. And that's the party's business. So that's what the court does. I couldn't deal with all those on my own anyway. It would be impossible, but it's unnecessary because pro forma. They're some just formality in many cases. And until it gets serious, present, then I'll be able to move on it. In y'all's case, work together. The team is more powerful than individuals working in different directions on this for the same goal. You represent him, and you got your interests here that are at stake in your constitutional rights. Work as a team. That's the way it's always done. We never have problems. Fix this. And that's in your best interest and everybody's best interest. Okay? It's set for trial. If the most cases are disposed of without a trial, 95% are disposed of without a trial. If that's the way it's going to be done, let me know. And then
That's the route that I would take. Yeah.
if it has to be a trial, we've done 600 trials.
Yeah.
So we're not afraid to try cases. And that's what this is for. Okay. Fix it. Be ready for trial or let me know otherwise.
Thank you.
Okay, thank you. Dior, Frazier, David, Grove. I hadn't even seen David. I don't know, somebody shouting from the.
Was it last night here? He is on his way.
He's on his way, according to my coordinator. John West, Jonathan Thomas.
That's
Okay. That's a continuation of a hearing we started, Judge. I've got 2 witnesses I need to present.
Okay, and let me go on, let me check on Daniel Moten. Mr. Moten? Danielle? This is Daniel Gary Moten. That's a female?
no, the female is Charmin Mint from yesterday. Mint.
Okay.
There are 2 females back there, so I'm here.
Daniel? There, I know Mr. Moten. Yeah, I recognize him. No, he's been here before.
Yeah.
Not long ago.
Yes.
Daniel, what are we doing today? Oh, you don't know. Well, it's a review of.
Yes.
Okay, and
Ultimately, Judge, if I may, just to bring you.
are you representing him?
That's what I had to hear.
There's a.
No, I'm sorry. Never mind. No. I thought it was, never mind, I'm sorry.
Thank you for your appearance, though. It was nice.
Judge, I can bring you up.
It's a fee issue.
Yes, sir.
Okay, there's a motion to revoke probation that had been filed last year. And this is about, these are done as you're nearing the end of probation. You were on probation for 10 years for aggravated assault. Well, it says 8 years. And then it was extended 2 more years. From 2014, when you were placed on probation, August 11th. So 8 years have been in 2022. Then it was it was extended to August of last year. And before that anniversary of 10 years was reached on August 11th, or it would have been, August 11th. Then July 9th, a month before that anniversary date, a motion to revoke probation was filed, which is normally done when there's a fee issue. They get a foot in the door, so the door doesn't close. It would close if nothing is done and 10 years elapses, then you would have been terminated from probation. But in your case, it's all about restitution. It looks like. I mean, there was a lot of restitution ordered at the beginning. I don't know what the balance is, but it looks like it's a little under $50,000. So that's why we're here, is trying to collect money for the victim.
Actually, Judge, what we were here today for is USD. Well,
Go ahead.
It's an administrative thing. The question came up about why the victim hasn't been receiving restitution. The defendant complained about that. You asked the probation department to look into it.
I'm concerned about victims.
Judge, the reality is that the victim was compensated through the Compensation Act and we had to pay them back first. They've approved.
Wait, paid them back. Them is the victim compensation?
Yes.
Entity?
That's what's been happening. We needed to get the numbers on that. She's prepared to give you the details as to all that.
Somebody's paying it.
Yes.
And it can't be, if it's Victim Compensation Act people, that's the taxpayers. And I'm not interested at all in being part of paying restitution that I wasn't responsible for. So it's the responsible party ultimately absorbs the cost. Sometimes a government entity is formed to help the victim get their money as soon as possible. Then the governments, the taxpayers, the people who funded that, actually to get to the hands of the victim as soon as is reasonable, then it gets repaid so that the taxpayers aren't footing the bill and paying for an indebtedness that they weren't the cause of. Then that's your responsibility at the end, Mr. Moten, that you've been trying to handle.
So we've got the breakdown for you, Judge.
All right.
Judge, if I may, the crime victim compensation paid in $9,237. Again, that's $9,237.91. And once we had the number for the CVC, all the restitution, 100% was going straight to them first to get them paid off. As of June 13th, 2025, just recently, he paid his $500 that the defendant paid his $500. And like I said, everything was going to CVC. He is currently paid off CVC in full. So now moving forward, any restitution that you order, $500 each month, is going straight back to the victim individually.
How much, what's the balance for that?
The balance on.
I think that's what we're all interested in knowing.
That is.
He needs to know when his $500 payments stop.
His balance on that's going to go to his father, the victim, is $42,731.29. And he has been making his $500 that you've requested monthly. Now the full 500 will go to his dad, the victim, moving forward.
Which is a balance of $42,731.29.
Yes, sir.
You understand that?
Yes.
Mr. Moten. Well, that's, we're talking about 83 months. I mean, it's a lot of time, but it's what it takes to fix the mess.
Yes, sir.
Okay. So
He's
we,
paying
good.
himself.
Otherwise, he's on an inactive state.
He's been that way for over 2 years.
It's just a matter of him coming in monthly and making payments. If you happen to win the lottery, don't spend a lot of money on that because that's a losing deal. But if you happen to win the lottery, that can help pay this off.
Yes, sir.
But keep doing it in a responsible way. Okay, the victim is your father.
Yes, sir.
I don't mean to be,
You've already addressed that, Judge.
working out.
Yes, sir.
Okay.
I am allowed to say, right?
Yeah, we've addressed all that through a memo that was handled 2 months ago.
If the victim wants that, that's what he wants.
We've
Yeah, I'm all for a father and a son
Yes, sir.
repairing any problems.
That's all been monitored by the probation office through your efforts and what you asked of everybody, Judge.
Okay, good. Well, repairing putting the family unit back together and the other way is repairing by the loss, and that's how you fix it. Okay. Then I think we'll just review in 6 months just to kind of keep an eye on things. Is that okay? Thank you very much, everybody, for being part of this. It looks like this is working. Appreciate it.
Okay, that's all for all the time that's been, yes, but okay, just want to make sure if something changes, you need to listen.
On is it Jonathan Connor?
Yes, sir. I'm ready.
That's gonna be the next hearing.
Judge.
Okay.
I'm sure we'll do that very last.
Do you have any?
I think so.
Have a plea.
All right, let's do a plea.
I have a plea.
Go ahead. Let's get that done.
This Milton,
Welcome, thank you.
Yeah. I double checked.
But Haney,
I guess it's, all right.
from yesterday?
Yes.
Okay.
She was the one I think had gone and had to leave.
We switched it and gave it to John. She should be at the bottom.
Yeah.
There's 2 files.
2 files. Come on.
She's.
Oh, she's out.
Testing. She's in testing. Bring her out right now, girl.
You made her upstairs.
She's-
After the time.
Oh,
There is a plate. I apologize.
okay, we've got 2 cases. What's going to be done?
5 years deferred probation, $500 on each.
On each?
Yes, sir.
Okay.
Yeah.
No restitution.
Yeah, no restitution, so.
Yeah.
One more spot on that, if you will. That's what he thinks. There's no delay.
Look, she tested positive yesterday. Don't we need to do a drug test? Make sure that she's negative?
Well, I mean, I don't know how long it'll take to get out of the system, so.
Just because it's in her system doesn't make her intoxicated.
No,
I understand.
But she's been overnight.
Are y'all insisting that we move forward together?
Good. I mean,
And there's
a reason.
Yeah, you've spoken to it.
Oh, yeah,
If there is
exactly.
any reason to believe that the defendant is incoherent or does not understand the proceedings?
No, she understands everything.
Ms. Milton, you understand where we are and what we are doing?
Yes, sir.
Okay, and Mr. West is going to help you on this. You were charged in 2 cases, 23 CR 905, forgery of with a financial instrument, that is a state jail felony, and 23 CR 907, which is fraudulent use or possession of identifying information, and that is also a state jail felony. Does the defendant waive formal readings of these indictments and arraignments? Can we proceed in summary?
Yes, Your Honor, please.
In summary, each of these indictments similarly state that on or about January 31st, 2023 in Jefferson County, Texas, you committed these state jail felonies that I described for you in these cause numbers 23 CR 905 and 907. You understand from speaking with your attorney what you were charged with in each of these cases?
Yes, sir.
These are state jail felonies, which mean that you face no less than 180 days, up to 2 years in the state jail, and a fine up to $10,000 can be assessed for each case. Do you understand?
Yes, sir.
Hmm. 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 What he's doing. Agreements have been reached. Well, even to the record, we're fixing the pad.
Yes, Your Honor, the agreement is on each case, 5 years deferred probation, $500 fine, no restitution and currently.
All right. Or is it your understanding, as Mr. West has just read out loud, that the plan is you would be pleading guilty on each of these cases, not found guilty, but placed on deferred or unadjudicated probation for up to 5 years? And was there a fine? $500 fine in each case, and there would be terms and conditions of probation, which is normal and customary for this type of offense in each case. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in each of these cases, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will. And because you are indeed guilty of each of these charges in these 2 indictments.
Yes, sir.
I'm going to show you in each case what's marked as State's Exhibit 1. Did you sign these documents?
Yes, sir.
Understand them, discuss them with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 was tendered into evidence in each case.
No objection.
Without objection, admitted. Among other things, they state that you are mentally competent to enter your guilty plea. These are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read it. You're guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that true?
Yes, that's true.
Let me tell you, this pad is.
Here, switch with me.
Oh,
Watch it back
it's,
The battery is really low on that brush. Get like us. Pull up what you need.
yeah, it doesn't want to pull up right now. It's stuck. It's.
No, it wasn't charged. Only do one at a time. So leave mine. Mine to me.
Fine, 500 on each. Yeah.
Oh, it's not working. This is not working.
So the game if it's not.
I don't.
Whenever you get out. Oh, 05? Are we on 07?
I think it's 05. Trying to open.
You do 07?
I think I already did 07 and that closed fine.
Yeah.
Check it.
Yeah. I don't have any of them back to you because I'm not logged in.
You see your initial unknown.
Yeah. Right. Thanks. They're locked with us.
Stand by, everybody. Smoke them if you got them. What's the problem on this thing? Is it me?
Loosen up behind the wheel.
Sir, you're walking the rest of the trip. All right. In each of these cases, ma'am, I show you what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents true and correct? You have to speak out. Yes, they're all true and
Yes,
correct. Okay. State's Exhibit 1 is tendered into evidence in each case
No objection.
without objection admitted. And again, these state that you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confirmation, cross-examination of witnesses. God bless you. You are totally satisfied with the representation provided by your lawyer. All true, so help you God.
Sure.
States Exhibit 1 in each case made a part of the record for all purposes. Pre-sentence reports waived.
Please, Your Honor, yes.
I'm going to follow these agreements. If nothing further, I'm going to find you, ma'am, Ms. Milton, you are pleading guilty in each of these two cases voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt in each of these cases. But I'm not going to find you guilty. So long as you follow these terms and conditions of probation, you will be placed on deferred or unadjudicated probation for 5 years to run concurrently at the same time. You must pay a fine of $500. There will be other terms and conditions of probation, which are normal and customary for this. Make sure you follow these. If you fail to follow the terms and conditions of probation, your probations could be revoked. You could then be found guilty of these felonies and sentenced up to 2 years in each case. Okay. Oh, you're going to do well, aren't you? All right. Fix this. And the probation officer will go over all of this with you here in a moment. Thank you.
Oh. That's what you want.
Yeah.
I need bumper.
Yeah. Come on, here you go. Yes, she's gonna need to finish up. That's the rest of it.
Okay, hearing,
Oh, John, can you pick that up, please? Just straight to. Oh, no. Just more something with us.
is it Jonathan Connor?
Yes, I have something left.
Okay, come on in.
Well, he's in
Mr. Connor?
his cousin, so we'll have to, we'll have to take him, we'll sit right here.
Thank you, sweet.
Take care, bye.
Okay.
John, I am going to have to get more.
Good, good.
Going ready here. Yes.
Okay, Mr. Grove is still on his way?
Is here, Judge.
It appears that way. Okay, those are these, and then all the other two, Mr. Connor. Okay, have a seat right over there, sir. Thank you. Okay. This is a continuance from June 16th?
Yes, sir.
All right.
You gave me an opportunity to present evidence on count one.
Yeah. 20, the case calls, the court calls cases 20-35195 and 20-35435. In each case, it's the state of Texas versus Jonathan Bernard Connor. Mr. Connor is currently on deferred adjudicated probation for assault on a peace officer, a second-degree felony in cause number 35195, and also another assault on a peace officer in 35435. Now, we started a hearing on for the first amended motion to revoke unadjudicated probation in each case which had been filed May 12th of 2025. The court swore the defendant in and over the fact that the defendant in each of these motions was alleged to have been placed on deferred or unadjudicated probation for 10 years in these two cases on July 24th, 2024. And the defendant answered affirmatively. Then the defendant entered pleas of true to allegation number 2 in each case, failing to provide verification of performing community service hours as required for probation. 3 in each, allegation 3 in each of these motions in each case, which alleged he was at a location of past his curfew by being at a location other than his residence at about 2:35 a.m. on or about April 13th, 2025. And he entered pleas of true to allegation number 4 in each motion, which alleged he failed to provide verification of entering and successfully completing the anger management program, and entered a plea of true to what's called first amended 6, number 6 in the motion to revoke probation, failing to report to the Jefferson County Probation Office for the months of February, March, and April of 2025. All of those in violation of the deferred adjudicated orders in each of these cases. All right, the state, we continued this hearing and the state has additional evidence to present.
Yes, Your Honor.
All right, again, the defendant, his attorney, Mr. West, and the state's attorneys are present. Go ahead, Stan.
Yeah, at this time we'd call Kirk Smith.
Please come forward, sir. Raise your right hand, and you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth. So help you God. Yes, sir. Please have a seat. Thank you. And this is going to be evidence as to
Count one.
allegation 1, committing continuous violence against the family on or about April 13th, 2025 in Jefferson County, Texas.
Yes, Your Honor.
As alleged in each of these motions is violation number 1 of his probation order.
And I will inform the court, my intention is to prove up the assault that occurred on April 13th.
Okay.
The nature of that particular charge would require evidence as to all of them, so I'm relying upon the lesser included offense. All right, sir, state your name for the record. And what do you do for a living?
Sworn police officer since January.
Yeah, help him with the microphone. So, yeah, thank you. It's what we call.
I
a
know that
direct-
part you were sitting back, I wasn't paying attention, let's move it up a little further.
Yeah, we have-
That makes it a little more.
What we call a directional microphone, and you have to speak right into it, but it works when it just doesn't catch surrounding voice.
Well, you said you're a certified peace officer
Since January 24th.
and working for which,
Working for the Beaumont Police Department.
all that time frame, sir? Or?
No, sir, I worked for the Beaumont Police Department and also Mount Bellevue Police Department.
So were you working in that capacity back on April 13th of 2025?
Yes,
And did you receive, what shift were you working?
the midnight shift
All right, so that covers what time frame?
from 9 p.m. to 7 p.m.
So did you receive a call out at about 2:30 in the morning?
Yes, sir.
And to what location,
Perfect.
please?
The address was 2950 Dowling Road, CBS.
Is that here in Beaumont, within the Beaumont, Texas, within Jefferson County, Texas?
Yes,
And again, that time frame was 2:30 in the morning, correct?
yes.
What was the nature of the call out?
It was reference to a disturbance
So you arrived on scene, what did you do?
and of locating the 2 parties involved in the disturbance inside the store.
They were inside the store
Yes,
and you saw both of them there?
yes.
And who were those 2 individuals?
One was a Jasmine Victoria and the other was a Jonathan Compton.
So let's start with Mr. Connor first. Do you see him in the courtroom here today?
Yes,
Can you point to him and identify something he's wearing?
and the
Your Honor, may the record reflect he's identified the defendant, Jonathan Connor.
Yes, it will.
All right, so you see the 2 people. What's the next thing that takes place inside the store?
going to speak with Mr. Compton.
And what happens with Miss Victoria?
She goes to speak with my partner,
And who's that?
Officer Compton.
And he's here to testify as well, right?
Yes,
So is that kind of normal when you got 2 suspects in a disturbance to separate them,
yes, sir.
gain information?
Yes, sir.
Did you do that with Mr. Connor?
Yes, sir.
Did he make any admissions about the offense that we're here talking about?
No, sir.
What was his basic explanation about what took place?
He stated that they both got into verbal argument.
Nothing physical, correct?
Correct.
So you've gotten your version. What's the next thing that you do, sir?
Then I go speak with my partner, who's speaking with the other party.
Did you overhear him talking to that person?
Yes, sir.
And did you make a decision? Did you make a legal decision moving forward based upon what you heard?
Yes, sir.
Okay, so what did you decide to do?
Based off of the information that was provided, decided to take Mr. Connor in custody for assault and violence.
Did you actually overhear her say that she wanted to press charges?
Yes.
Objection, Your Honor, your side.
Just a.
I'll get into the specific statements and reasons why I want to do that with a separate witness, Judge. All right, so when you stepped out to visit with your partner and get more information, where was Mr. Connor?
Mr. Connor was inside the store.
And what was he doing at the time that you left him in there?
I believe he was continuing with grocery shopping.
In hindsight, was that a good decision to leave him there?
No, sir.
So how long were you outside and determining that he needed to be placed under arrest?
It was probably a few minutes.
Okay. So you go back into the store What do you see?
Did not see Mr. Connor.
No longer at the checkout.
No, sir.
Was he actually in the process of checking out groceries from CVS
Not when I walked away from the phone.
when you left? Was he?
Yes, sir, when I left.
Were those groceries still at the checkout?
Yes, sir.
Did you determine where he was?
We ended up locating him in the bathroom.
Okay. And did you place him under arrest at that stage?
Yes, sir.
Did he give you any problems?
No, sir.
Is that pretty much the extent of your dealings with him there at the scene?
Yes.
Now, I think I asked you this earlier as far as when you initially interviewed him, he didn't make any admissions about the offense.
No, sir.
Did he make any admissions later as you placed him under arrest or even when he was in your car, custody, the ride to the jail, any time in that time frame?
I don't recall.
All right. No further questions of this witness, Judge.
Anything from defense?
Just a quick question. When you placed him under arrest, you said there was no issues, correct?
Correct.
He was cooperative and went with you with no problems.
Yes.
Okay, polite and as can be in that situation.
Yes.
Okay, pass the witness.
May I approach Judge?
Yes.
All right, I got you to identify Mr. Potter. I'm gonna show you what I marked as state's exhibits. 1, 2, 3, and 4. Do these photos appear to be representations of Miss Victoria?
Yes, sir.
Is that how you saw her that evening?
Yes, sir.
Do these photos indicate injuries that she suffered?
Yes, sir.
And did you see those injuries that night?
Yes, sir.
Do all those photographs, states exhibits 1 through 4, truly and accurately represent everything that you saw that night on April 13th, 2025, there at the CVS pharmacy in Beaumont, Jefferson County, Texas?
Yes.
Nobody added or deleted anything in here.
No, sir.
And you feel the forth that this is in fact Miss Victoria and the injuries she's reportedly suffered on evening.
Yes, sir.
We would attend state's exhibits 1 through 4.
No objection, Your Honor, I've seen this.
Admitted.
I'll send them to the court. I will use them with them in a separate witness. No further questions of this witness.
Nothing further.
Can this man be excused?
You can, Your Honor.
You're excused, sir. Thank you. Next, please.
Officer Heath Holmes. Or if you can go if you want, or you can say if you want.
Raise your right hand, sir. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat. Thank you.
State your name for the record.
Keith Holmes.
What do you do for a living, sir?
I'm a Beaumont police officer
How long have you worked as a Beaumont police officer?
since December of 2022.
And were you working in that capacity back on April 13th of 2025?
Yes, sir.
Yeah. What watch were you working?
First block.
And is that, tell me the time frame.
It's 9 p.m. to 7 a.m.
Right. Did you receive a call out to go to a CVS here in Beaumont within Jefferson County, Texas on that date?
Yes, sir.
Was that at the CVS located there at 2950 Dallin Road?
Yes, sir.
What was the nature of that call out?
It was a disturbance.
And what did you do when you arrived there, sir?
Me and Officer Smith went up to the front of the business. We didn't see anyone outside. I was flagging us down. We walked inside. We saw 2 customers inside the store that we just found with. They complaining and supposed actor. That was a little disturbance.
So was the timing of this incident around 2:30 in the morning, sir?
Yes, sir.
I think you were in the courtroom when I was talking to Officer Smith.
Yes, sir.
All right, so you know that state's exhibits 1, 2, 3, and 4 are in evidence. Do you recognize those items?
Yes, sir.
Is this in fact the lady that you visited that's represented here in States One? Is that Miss Victoria?
Yes, sir.
And Officer Smith indicated that whenever y'all came in, that he took the responsibility of talking to Mr. Connor and you took the responsibility of talking to Miss Victoria.
Yes, sir.
Is that true?
Yes, sir.
So do you see Jonathan Connor in the courtroom here today?
Yes, sir.
Can you point to him and identify something that he's wearing?
Wearing a red shirt.
He's identified, may the record reflect that he's identified the defendant, Jonathan Connor.
Yes, he will.
All right, so you walked outside with Miss Victoria?
So,
Did you say you walked outside with Miss Victoria?
yes, sir.
So were y'all trying to separate these two individuals?
Yes,
Is that kind of the norm and the procedure for domestic disturbance?
absolutely. We try to do that every time.
And describe to the judge what her demeanor was.
It's been a little while, but from what I can remember, she was, I don't want to say amped up, but very, she was very like off-puttish, I guess you could say, of kind of just didn't want to be, I get scared, I can say.
Scared?
Timid would be a better word for it. She just didn't.
Did you see those injuries that are depicted in State's Exhibits 1 through 4?
Yes, sir.
And did you know that you were there investigating potentially an assault situation?
Yes, sir.
So took her outside. Where did you continue to talk with her?
Initially, we just walked outside, and then being that she was so uncomfortable, I could tell, I asked her if she wanted to sit in the back of my car, if she was more comfortable there. She said yes. She sat in the back of my car, and that's whenever I began talking with her.
Was she forthcoming about what happened to her?
Yes, sir.
And during the time in which, I'm going to ask you about some of the statements that she made. And I want the court to be educated about whether or not she was in an excited state or whether or not she was just giving you a present sense impression of what took place. What's your opinion about that, sir?
Can you answer one more time?
Was she in an excited state? You described timid, you described scared. Did she seem reluctant to give you the information?
That's a much better way to put it.
Okay. Was it because you're a police officer, or in your opinion, or is it because of what she dealt with?
I think it was more so, it could be a combination, but it is very common. But I think it was more so the situation that she was in.
Did she seem to have recently been through the events that she's describing to you?
Absolutely.
And what, in your opinion, was she giving you an impression of what those events were?
Yes.
And was it from, how recent were the events that she's describing to you?
She described several events, if I remember correctly, 3, dating back a week, or 3 different times. Specifically, the one that we focused in on.
Objection, Your Honor, here say.
I'm not going into the statements. He's giving backgrounds at this stage, Judge.
So I'll make sure that he doesn't talk about it.
Go ahead. I'm laying the groundwork to get into the hearsay statements.
Yeah.
So she's giving you, as she's talking to you, she talks about this has occurred over days.
Yes, sir.
So just as, did she get as to what happened that night?
Yes, sir.
Did she tell you details about what and when those things occurred? Well, let's be specific. Did she tell you how she got these injuries?
Yes, sir.
Did they happen on a recent situation from what you're looking at here?
Yes, sir.
Did it fit with what you saw here in states 1, 2, 3, and 4?
Yes, sir.
So timing, officer, is what I want to get back to. As she's relaying this information to you, did it happen hours ago or minutes ago?
She described both. It was an hour before, and then also while she was inside the store.
So y'all got a call to go to the store, and it sounds like something happened then, right?
It sounded like a continuous event up until we arrived at the store.
Gotcha.
I'm sorry, from about an hour before on up until whenever we arrived.
So. Hold that thought, Officer, for 1 second. So these descriptions, these statements that she made, did they describe an event or condition that either occurred immediately before or sometime leading up to it?
Up until the call?
Yes.
Yes, sir.
And do you believe that she was under the stress of that event as she's relaying it to you?
Yes, sir.
I mean, it's literally minutes before you guys got there, right?
Correct. Yes, sir.
And I'm gonna tender that the questions I'm about to ask meet the exceptions under 803. 1 and 2 specifically since she made that we've been building around that she told this officer took place that night.
Your Honor, I would object to those statement. The exceptions to hearsay are regarding statements made by a defendant. These are questions or answers she's giving to questions. He's asking her about what's going on, not that she's just excitedly uttering, "Oh my God, he hit me," or something like that. That would be different. That's what excited utterance and those exceptions are for when police officers show up or people show up and somebody's making statements unquestioned or provoked. In this situation, these are not excited utterances or exception to hearsay because these are him pulling her outside to question her about what's going on. And that's what the rules of hearsay are, prevent people from making statements that are made outside of court. We don't have the victim here to cross-examine and to find out what's going on here. So I would say that these are hearsay and they do not fit the exceptions to hearsay.
Okay. This court was on the committee that wrote the rules of evidence. Okay. What wrote the rules of evidence. And it is clear hearsay as defined in hearsay is generally inadmissible. We carved out 24 exceptions to that rule. Not the least of which, or what the state is contending, and were the very first two that were written, present sense impression and excited utterance. If those fit the definition, they are clearly an exception to the rule against the admissibility of hearsay. In other words, they are admissible. But let's be clear what each of these are defined as. Excited utterance exception, and then present sense impression. An excited utterance, again, is the product of a startling event, and the statement is made while or immediately after being perceived by the declarant. And it is describing or explaining an event or condition. As to that is concerned, this court's a little unclear about what the timing is on that. I'll give the state allowance to make it clear. Excited utterance. Okay. An excited utterance on the other side of the coin there as number 2 exception. It's, a present sense impression. A present sense impression is distinct from an excited utterance and requires a statement describing an event or condition that is made while or immediately after the declarant perceiving that event. And we're talking about present sense impression, number 1. Excited utterance is a statement that relates to a much earlier incident. So the timing is not immediately or spontaneous, but can relate to an earlier instant that triggers a statement being made by the declarant, the person perceiving it. And it is made, the test is, was the declarant still under the stress of the excitement that that event had occurred that caused the declarant to make the statement? So an excited utterance can come about much later than the present sense impression, which is what is happening immediately or at the time or immediately thereafter. Both are admissible depending upon the circumstances, if it fits the element. Go ahead. Stay.
All right, so, officer, I know that she made statements to you about events that led up to this particular night, but for the purposes of what happened here and what she said, I want to focus in on what she told you about what happened right there at the store minutes before you guys got there. You understand?
Yes, sir.
All right, so that kind of helps us deal with the timing of these incidents, right? I'm not asking you to parrot back what all she said, right? But I want, in my attempts here with questioning you, I want to focus in on that for the purposes of our timeline. You understand where I want you to go?
Not for the timeline alone.
All right, so I'm aware that while she's talking to you, that she told you about events that happened days before and things that led up. Am I right about that?
Yes, sir.
Okay. I also believe, based upon what you've said, that she told you what immediately happened that led up to y'all getting there and the reason why you were there.
So the event that we're called there.
I want to limit it to just that.
Yes, sir.
If I can. All right. So, did she describe to you the assault that occurred there at the CVS pharmacy?
Yes, sir, she did.
What did she say happened?
Objection, Your Honor. I don't think you made the ruling. Objection here saying.
All right, I'm going to allow it for the purposes of the court hearing as much information about the circumstances to make a decision on your objection.
Thank you.
What she tell you happened right there at the CVS?
Yes, sir.
What did she say happened?
She said that she was assaulted by Mr. Connor.
Did she go into how he did that? Like, okay.
She said that, we said 3 to 5 times she was punched in the face, which more specifically, she said that the large curving bruise that's coming from her forehead above her right eye, that was caused by being punched 3 to 5 times by Mr. Connor.
So when we look at State's Exhibit 1, this is the lady that we're talking about, right? This is the lady that you're talking to.
Yes, sir.
Did you take these photographs?
No, sir.
State's Exhibit 2. This here, is that goose egg is what I'm calling it.
Yes, sir.
Is that what you saw that night?
Yes, sir.
Did that fit with what she said? That she was struck 3 to 5 times by Mr. Connor? That's what Paul said.
Yes, sir.
Did she describe to you how the injuries occurred on 6?
Yes, sir.
What did she tell you? First off, before you go into that, was it something that happened that night?
Yes, sir.
Recent in time?
Yes,
There
sir.
at the CVS?
This was from a specific incident, so we hopeful.
Thank you. I want to work within that same frame. So how'd she get the bruise that we see in states 3 and in states 4 that appears to be on her right arm?
Yes, sir.
How'd she get that?
She said that was from Mr. Connor grabbing her.
that the extent of the statements that she made to you about merely in time frame that the assault that occurs on April 13th?
Can you ask it one more time, sir?
I'm trying to make sure that we've gotten all the statements about what happened to her that night at the CVS.
Yes, sir.
I know she told you about other incidents.
Yes, sir.
We're not going into that right now. And I would tender that that's the testimony that I'm offering under those exceptions. I have more that I want to go into here, but not as to the hearsay exceptions.
I still have my objection on it.
All right, I got a problem with them. It's still not clear in the record. The timing and the most on present sense impression, again, that is truly based upon the timing of the event. It's made while or immediately after the declarant had perceived it. I'm still not getting any information when the event occurred and when she is talking to the witness. The excited utterance. The key there is the defendant, is the declarant still under a state of stress of the excitement that had occurred, which caused the statement to be made, which could be a while after the event. The question is how is the declarant, what condition is the declarant in?
I understand, Judge. If I may.
Go ahead.
All right, so in your discussions with Miss Victoria, did she tell you when those injuries took place?
Specifically the ones that you showed me pictures of, was she told me it was from that night. I don't recall where exactly they occurred, but she said within, it was about an hour prior of our conversation, which we'd probably been on scene for 10 to 15 minutes. So I'm not sure.
So within an hour?
Yes, sir.
Did she indicate if it had occurred at anywhere at any other location other than the CVS?
Yes, sir.
Okay. And that was that particular night too?
Yes,
correct. Did she indicate that did any of these injuries occur right there at the CVS? So when you said that she was struck 3 to 5 times in the head?
Yes, sir.
That's the how of how she got states to do 1 and 2. When is the question?
Correct.
Did she tell you when?
I'm sorry. No.
Sir?
I think where is where I'm not sure when she's told me within an hour.
Within an hour.
Yes, sir.
That's true for states 1, 2, 3, and 4.
Yes, sir.
All right, so let's move on to the second. Second part of that question that I'm submitting, sir, is was she under the stress of that excitement? Was she still working underneath the stress of this incident that she described to you, in your opinion?
Yes, sir.
Why do you say that?
Based off her demeanor, her actions of not only was she trying to get further away from, I tried to bring her initially I got pressed at the front doors and she just kept on trying to get further and further, trying to get in, then got inside of my car. Not usual. We were wanting to get in the back of the police car, but she wanted to get in the back of the police car to even talk to me.
And she stayed in that state of being through the time frame that you were talking to her?
Yes, sir.
And do you feel like she was still relating the events and the conditions that took place?
Yes, sir.
And in your opinion, still under the stress or excitement of that particular event,
Absolutely.
which from your understanding was something that occurred sometime within the hour of whenever you got this statement.
Yes, sir.
That's what I have, Jeff.
Continue, my objection, Your Honor, and to address each one of these, exceptions to hearsay. As far as the president's impression, I'm sorry, Your Honor, this was not made. It could either be made while or immediately after. It's not made while, so we don't.
The
even
question
look at
is within an hour and
Is
it's
that-
certainly not while it's happening.
Right, so it goes to the next part, is it immediately after? I would argue that an hour later is not an immediate time right after that. It's one thing if they show up and it just happened right before they showed up, like
Okay,
they
go to the next one then.
Okay. As far as excited utterance, Your Honor, these statements by her were not made out of excitement. They were made as response to questioning. This is not an excited utterance. I would argue that an excited utterance is more described as, like I said, the officer showed up, she comes around the store going, he hit me, he hit me, he hit me. That's an excited utterance, and there's no argument. This is where they found these individuals together in the store, broke them apart, pulled her outside, put her in the car, started asking her questions, and then she gave information. This is not where she was just voluntarily giving information to the officers. That's an excited utterance. This is an excited interrogation, and that's not one of the rules, or one of the exceptions to the rules. This is still, everything she said to this officer is still hearsay, Your Honor.
Okay. Overruled. That's not the intent. That's not the way it's worded. Excited utterance is called excited utterance. It's, again, a statement relating to a startling event or condition made while the declarant was under the stress of the excitement that it caused, which the witness has clearly described. It fits that definition, and your objection to present sense impression is sustained. Your objection to excited utterance, it's overruled. It is an exception to the hearsay rule. It is admissible. Go ahead, Steve.
So your partner comes out of CVS, or y'all were riding together. Officer Smith comes out.
Yes, sir.
Do you hear him approach?
I don't recall if I heard it or not.
Do you recall asking her if she wanted to proceed with charges? And
Yes, sir.
those are all normal steps and all, right? You finished up your investigation, correct? As far as that discussion and all. I used the wrong
For
word.
the time being, yes, sir.
Yeah, I know there's more that's coming. But you finished your conversation with her,
Yes, sir.
made a decision to move forward with probable cause for arrest.
Yes, sir.
Did y'all then move forward to do that?
Yes, sir.
All right, so again, you were present when Officer Smith talked about this. Did you follow him in to help locate Mr. Connor?
Yes, sir.
Where was he?
Mr. Cross,
Yes.
he was inside of the bathroom.
So tell the judge why you found that out of the ordinary that Mr. Connor was in the bathroom.
So they're checking out their groceries, their other groceries up on the counter inside their basket. Officer Smith, whenever he came outside, he left them there to finish buying his groceries, because from his understanding, what he was told by Mr. Connor, that the disturbance which had happened inside of the store, all verbal, the reason that we were there. And so Officer Smith came outside and figured out what I had learned on we have injuries, an assault occurred, they're in a dating relationship. This needs to be separated by arrest. So we both went back inside of the store, believing he'd still be right there with all his groceries. And all his groceries in his cart were still up by the counter. And we asked the workers, where did he go? And they said that he was walked to the back of the store.
Right. Let me stop there for a second.
Yes, sir.
Yeah, you stated one thing that I failed to mention. You all determined that these two individuals were in a dating relationship.
Yes, sir.
Okay. And you could state that affirmatively, that you did that as well, correct?
I'm sorry?
You determined that as well, correct? That Mr. Connor was in fact dating Miss Victoria.
Yes, sir.
All right. That's the nature of family violence.
Yes, sir.
Yeah. All right. So Where did you ultimately find Mr. Connor?
He was inside of the restaurant at the back of the store.
What were your concerns about, hey, he's not where he said he was gonna be, he's in the bathroom?
My concern is he knows what happened. He knows what she's gonna say. He knows where he's about to be going, be in jail. He's discarding some type of evidence, firearm, weapons, narcotics, nothing like that.
You think he's disposing contraband or evidence?
Yes, sir.
Right?
Yes, sir.
So did he come out?
Yes, sir.
Did y'all handcuff?
Yes, sir.
Did he give you any problems one way or another?
Yes, sir.
Right. So you thought there might be contraband, so what did you do?
I walked in the bathroom, looked inside of the trash can, which was immediately to my left.
What'd you find?
A, I typically call it a crack pipe, it's a clear glass pipe with a bulb on the end of it, which had burnt residue of some type of drug paraphernalia.
Anybody else in the bathroom?
No, sir.
So he was the only person?
Yes, sir.
Did you take that item
Yes, sir.
and what'd you do next?
I think that I showed it to, or I stepped out of the bathroom and then thinking there's more. It's kind of a saying that we go by. It's typical of you find one thing, there's gonna be something else.
Yes, sir.
I remember that, walked right back over the trash can.
Did you find something else?
Yes, sir.
What'd you find?
A clear plastic bag with crystal methamphetamine inside, what I believe to be. There's a clear plastic bag wrapped around itself.
Did you take those items into possession for
Yes,
those reasons? I'm reading your report. It looks like y'all decided not to charge him with the possession of paraphernalia,
Yes, sir.
and those items were actually destroyed, were they not?
Yes, sir.
So at the end of the evening, y'all just processed the family violence assault, correct?
Yes, sir.
Did anything else take place that you're here to testify about, Officer Holmes?
Yes, sir.
That's what.
Warrant officer. Now this alleged incident, you didn't see it happen, obviously, correct?
The assault?
Yes.
No, sir. I did not
Okay.
see.
You and your partner were called to disturbance, so y'all got there after the incident happened. Y'all responded to that, correct?
Yes, sir.
Okay. So the only thing you're going by is what you were told by the alleged victim and what you saw on her, correct?
Yes, sir.
Okay. Yeah, like I said, you didn't see it. You're reporting to the court what you were told and what you saw, right?
Right.
Okay. Yeah. And you can't say if she was telling you the truth or not, can you? No, exactly. And like I said, it's not your job to decide that. It's your job to present what you saw and heard, correct?
Yes, sir.
Okay. Now, as far as the stuff found in the bathroom, he had been in the restroom before you checked it, correct?
Yes, sir.
Okay. But he wasn't the only one that had been in that restroom before you checked it, right? Okay, yeah. There are probably many people throughout the day going in there, right? Okay. And the drugs and the pipe and all that wasn't found in his person, was it?
Correct.
Okay. And ultimately, y'all decided not to charge him with that because you couldn't really prove or state that he was in possession of it there, right?
Yes, sir.
Enough to come to court, right?
Right.
Okay. All right. Pass the witness.
No further questions, Jeff?
Is this man excused?
Yes, please.
You're excused, sir. Thank you. Next, please.
State Express.
What's this defense?
Your Honor, regarding this issue, I think my client's already testified regarding all the other stuff.
Is there anything the state wants to, defense wants to present?
Not regarding this.
All right, summarize. State may go first and close.
Judge, I'll remind the court the call out for this original case. Let me ask, Judge, do you have a copy of the PSI?
No, not with me right now. No, we don't keep those here in these files.
You'll note from the original PSI that led to the items that Connor was on probation for is that 2 officers were called out for domestic disturbance. He was in an apartment and basically was refusing to let them come in. They could They had heard evidence of some form of violence going on, so they had reason to gain entry to determine safety of the individual. And the result is that that particular lady was assaulted. She would not move forward with charges. The offenses that he was placed on probation for was the struggle that ensued between Mr. Connor and the officers there that never should have taken place in the first scenario. That I point that out because that's the nature of what we're dealing with here. We've got a lady who is in a relationship with Mr. Connor. There's accusations about other time frames of assault, but specifically as to this instance on April 13th, we've got two different officers who observed fresh injuries that are in state's exhibits 1 through 4 that fit with what they were told. And the limited exceptions that we've got is that statements that were introduced is that Mr. Connor, who is in a dating relationship with Miss Victoria, caused those injuries. That's the nature of the lesser included offense of family assault that I told the court I would attempt to prove today. I believe that all the elements of those are there for the court to consider in a scenario for ponderance.
Now you're
of the
speaking
evidence.
about assault.
Family.
Under section 22.01, the
Yes,
lesser
sir.
included offense,
Yes, sir.
which defines assault as being a person committing an offense if that person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse.
Correct.
All right. And
So I'm asking for a finding of true as to that lesser included offense as to count 1 in combination with the remainder of those counts. Once the court enters its ruling on that, I'll have an opinion about the resolution.
okay. Defense?
Yes, Your Honor. Regarding the allegations, and I'm going to take them separately here, the ones that were discussed in the first hearing, he pled true to those. Okay, so those are issues here where we're asking the court to give him mercy. One of them is the money he could not pay. He paid what he could, so I don't think that's an issue for the court. As far as the anger management goes, it's something that he still had time to do, and we would suggest the court, if the court continues on probation, he can get that taken care of. As far as I think the big one here on these is the being out past his curfew, because we know that he was out past his curfew because that's when this alleged incident happened, and he even admitted that they were there. He mentioned that his car had broken down, that they were stuck there, and it wasn't intentional trying to be out past his curfew. Okay. I think based on those, the court should have some kind of mercy on him and some kind of administrative sanction or something like that, and continue him on probation. Now, the big one we have here is the new offense. This is the one we were talking with today. I would argue that the state has not met their burden to prove up that this happened, in the sense that the victim was not here to testify. One of the things is in an assault is I don't want to say consent, that's not the right word, but that may be what I need to say, is that if he did do what they're alleging he did, it's without the effective consent of the victim. Okay, and we don't know that. Okay, that's the problem here, is the victim's not here to testify what happened, what was going on, more of the details. All we have is what the officers were told that night and what they saw. Okay, and that's what I asked the officer about, and he's doing his job, doing a good job of just reporting what he saw that day, what he was told that day. But we don't know what was going on because the victim, the alleged victim, is not here to testify. Sometimes assaults are not assaults because there is consent, and I don't know if this is a situation where it was. We just don't know. That's the thing. For example, if
that would be an affirmative defense, right?
Yes, but there's nobody.
You could have called the lady.
Well, she doesn't want to cooperate. That's the thing
care.
here. That's what I'm saying.
It's not for me to
Yeah.
decide. I mean,
She
but
has
there are methods of bringing someone forward. If it's important enough, that wasn't done in this case.
Well, they still have to prove all the elements, and that's what I'm saying.
But you're saying you're stating an affirmative defense. That's not for them
I
to.
don't think it's, I'm not sure it's a affirmative defense, Your Honor. They still have to prove all the elements of the case.
No, once again, it's intentionally, knowingly or recklessly causing bodily injury.
Right.
Consent isn't in those elements. Or
Yes, sir.
lack of consent is not in the elements.
Right. Okay.
So that's not.
But still, the point is, Your Honor, the victim, they did not have anyone here testify regarding that. All they had was the officers testifying what was made available to them. And like I said, the officers doing their job. I'm not saying anything negative about the officers, of course. They were just reporting back to the court or testifying to the court what they were told. And I don't believe that that's enough to establish that he committed an offensive assault. Okay. So I would ask the court to make this ruling on the offense or the allegations that he pled true to, and we're not denying or defending those, and set his punishment accordingly to those and not to this alleged new offense.
Oh, any rebuttal or summary?
No, I don't think it's necessary, Jeff.
Okay. All right. There is no debate on allegations 3, 4, and 6. I'm sorry, 2, 3, 4, and 6 of the motions to revoke probation, as in each of those allegations, the defendant pleaded true earlier, voluntarily, knowingly, intelligently to those allegations, understanding and appreciating that a voluntary and knowingly plea of true to one or more violations of probation would be enough under law to grant the motions to revoke probation. Probation can be revoked, they can be found guilty and be sentenced up to the full range of punishment. So the court finds those allegations to be true based upon the affirmative representations, the voluntary statements made by the defendant in that earlier hearing we held in this case on June 16th, 2025. Allegation number 1, committing the offense of continuous violence against the family, and then what that dealt with under section 25E.11 of the Texas Penal Code. And it states that a person commits an offense if during a period that is 12 months or less in duration, the person 2 or more times engages in conduct that constitutes an offense under, among other things, section 22.01, subpart A, subpart 1 of the Penal Code against another person. The state admits that there isn't that element of continuous violence under assault is not proven. Section 22.01 A 1 is assault, and it is included in the elements of continuous violence as alleged for the violation. Thus, under law, it can be considered as a lesser included offense that could be used to subject the defendant to revocation of probation. And it states that a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse. The court finds that the state has proven through evidence that the defendant did commit the offense of assault by intentionally, knowingly or recklessly causing bodily injury. And it is also within the penal code definitions, bodily injury under section 1.07 definitions under penal code states bodily injury means physical pain, illness, or any impairment of physical condition. The testimony and the evidence presented shows enough that the victim in this case was exhibiting wounds or injuries from a recent occurring assault, and that together supports the conclusion that the defendant is in violation of his probation by committing the offense of assault on or about April 13th, 2025 in Jefferson County, Texas. Thus, the court finds number one to be proven true through the evidence presented today, and thus sufficient evidence is in the record to support these motions, first amended motions to revoke unadjudicated probation, and defendant's probation can be revoked. What do the parties say about what should be done next? State.
Yeah, I would re-tender in the PSI that for your education, the defense is going to be asking for a second opportunity for this defendant. And honestly, he's already had that. 2015, he was given a chance at probation, which he failed at. That was resulted in giving him a 4-year sentence. Really, the state gave him either his second or third opportunity whenever we gave him this probation. That was deferred in 2024. And so what we're dealing with here is 9 months later, he's still committing assaultive type behavior. And he has no compunction about it, doing it. He's out at 2:30 in the morning. And if he had any intentions of following your probation, this man would not have been there, would not have been in the circumstances, and would have been walking the pine narrow to try to prove his character. Instead, we have the opposite. I would recommend that for the protection of those here in Jefferson County that he loves to prey upon. I speak for the women that have been his victims in the past and ask that he get 8 years.
You're asking for 8 years in prison?
Yes, sir.
Go ahead.
Your Honor, Mr. Hannon is right. I am going to be asking to continue my probation regarding the allegations that he pled true to. Those are things that he can correct and fix and carry on, get his community service done, catch up on his money, do his anger management. As far as being out past time, that was a big mistake, and I would ask the court to the court wants to give him some kind of administrative sanction, for example, some jail time as part of his probation, to continue on probation. He's on deferred probation, or another alternative the court has, as the court's very aware of, revoke his deferred probation and put him on regular probation and let him continue to catch up and do the things the court initially told him to do that he just hasn't got to yet. Anger management, community service, things like that, and catch up on his fees and fines. So we would request either to sanction him with some jail time and continue him on probation, or to move it from deferred probation to regular probation.
Do you want to say anything, Mr. Connor? This is your opportunity to speak, but make sure that you run whatever it is you want to think about doing by your attorney. Okay.
First of all, Judge, I was going to say.
Stand up, please. Thank you, sir. Go ahead.
Jill Stevens, to my lawyer and VA, as well as my probation officer. I ask you guys for the for messing up on probation, not reporting the stuff like the thing that I did wrong. And I want to say that all those things about the young lady is not true. She was in a fight earlier prior that day, and that's why she was mad at me because I kicked her out of my house because I didn't want to get evicted because I had just got this apartment and I wasn't trying to lose it because I didn't have nowhere else to go. My mama left the apartment to me, so and I've been having problems with this girl, but I love her, so I try to give her another chance but she's I'm getting to the point where she's not bringing me no good, she's only bringing me bad. And even like right now, I'm going through situations that I shouldn't even be going through because of her,
I'm sorry, no. You're going through the situations you're going through because you bit police officers, and committed assaults on peace officers. That's why you're here in the first place.
Okay.
Don't forget, let's keep your eye on the ball. You shouldn't even be on probation, but no, you decided to commit aggravated assaults on peace officers.
So I said,
You pleaded guilty to those.
I did.
All right, you want to take those back? You were under oath. You want to try perjury as well?
No, I'm not talking.
You looked me right in the eye and said, I did this. I want you to put me on probation. You remember that? Do you remember that? All right, that's why you were here, sir.
Okay, but that's not what I'm talking about, Judge Stephen.
I know you wouldn't want to talk about that, but it's assaultive behavior, and this alleges another assault.
Okay, Stephen. To be honest with you, Judge Stevens.
Yeah, that would be nice. Be honest with me.
I didn't even assault those police officers, and I have proof of that. But I had a lawyer.
I want the state to consider filing a perjury charges for this man. He is making statements to this court, and you pleaded guilty voluntarily, knowingly, intelligently, under oath, saying I committed, and you're going to interrupt the court, Mr. Interrupter. You pleaded guilty under oath, and you're now looking me in the eye and saying you didn't commit those crimes? That's perjury.
I didn't even know that was perjury.
Oh, you just think lying is just normal?
No, I just don't know.
It has consequences.
Nobody never taught me the law.
Yes,
I don't know.
well, sir, we went over this real thoroughly.
And I did.
Hold on.
I do.
Hold on. We're gonna refresh your memory. This is important. I need the affidavit, the plea paper on the entry of the plea on either one of those. It's going to be the same one.
Now finish. Okay.
Stand by.
Yes, sir.
Oh, Leon,
Yes.
you're gonna be towards the back, on the right hand side. Not all the way back. I'll reprint them.
Yeah. Sometimes they don't put those in. It's in they're in the record because they have to be in the record.
And it should be done.
I just. What this court does not tolerate are false statements, because we've got to work on accuracy. Now, this court knows that people don't tell the truth from time to time. And
You have a very hard one. You know? Okay, I don't know. I don't easy. Don't get in trouble. I don't work. I don't have no record.
hey, sir,
Just
be quiet. Thank you. What makes this court angry is that we really can't resolve matters when people can't tell the truth. And we know that happens. When they don't tell the truth, they get called on it in this court.
I apologize to us once again. I didn't mean to not say you.
Well, maybe you just don't understand what perjury is, but it's lying under oath. Here's a statement you signed.
Yes.
This is your signature. There you are, right there. See your signature? You can see it. All right. See this yellow part? All right. This is sworn under oath. This is what we do in every case when people enter pleas of guilty and when they want to enter a plea of guilty. And this is duplicated in each case. And this is charging you with assaults on a peace officer that you were placed on probation for. I have read the charging instrument, the indictment, and my attorney has explained I committed each and every element alleged, which means you are admitting to assaulting the peace officers that a few moments ago you said I didn't do. I am guilty of the offense and all lesser included offenses charged against me in this case. Listen to this, Paul. This is really the catch. I swear that all of the following, as well as the testimony I give, is the truth. So help me God. So you interrupted once again. Let me make the point. You admitted under oath you were guilty. You swore to God it was guilty. And then you have the audacity here in this proceeding to say, I didn't commit those crimes. You just admitted or made a statement that is completely contradictory to what you swore to under oath. That's what we call perjury. Now, you want to take it back?
Yes, sir.
See, the problem is that you lose all credibility when you get caught lying under oath. And that's what we're trying to figure out, is what the truth is.
The truth is, I wasn't never talking about that.
Oh, we're going to believe you now?
But I was trying to tell you about a situation that I was having with this girl. But anyways, the thing about it is, look, Stevens, I truly apologize for everything that I've done. You know, all along I was I mean, I try not to do wrong. I try to do the right thing.
It's somebody else's fault.
It's never no.
Is it your fault?
It's always my fault, Judge Stevens.
It's always your fault? I'm talking about just this. I'm not saying asking you to take the blames for all the sins of the world. I'm talking about this case, this hearing, these allegations. Are you accepting responsibility for
I'm
it?
not accepting responsibility for those, no.
Okay.
As far as assaults for the police officers, yes, I accept the responsibility.
Oh, that's not what you said a little while ago, was it?
Probation. But Judge Stevens, I mean, come on, I mean, life has been kicking me in the butt, man. I mean, I just,
sir,
I said, like my life, things just hasn't been going very well.
Sir, life is what we make of it.
And I understand.
And everybody makes choices. Everybody makes mistakes. It's how you deal with your mistakes.
Yes.
You have made serious mistakes that you have not dealt with responsibly. And at this point, the way you respond to it is defiance. I didn't, by getting caught in a lie here, I didn't even assault those officers, even though you admitted under oath you did. That's what's important. We don't take these allegations lightly. This is serious. We have to rely on on the evidence. We have to rely on sworn testimony. We have to rely on the truthfulness to get to the bottom. And that's what this court has to do. This lady is injured. And it's clear that you were found responsible according to the investigation. And this court finds from the evidence presented that it meets the definition of assault. But you were on probation for assaulting two peace officers. You have no business assaulting another person, much less someone. Your relationship with this lady was what? Were y'all married or?
We was planning on being married.
Okay. You were in love with her.
Just
Wait. You were in love with her, right?
Yeah, I was in love with
Okay. This is, if you are going to assault peace officers who are doing their job, if you are going to be assaulting someone who you claim you love, what would you do to somebody that you didn't like?
I think it was something. Look, she got in a fight. She was mad. She was mad because I was kicking her out of my house.
Somebody else's fault, isn't it? It's somebody else's fault. Just like I didn't really bite those officers. It's somebody else's fault. Sir, I learned when I was young, you make mistakes and you're going to be held accountable when you make the mistakes. So you try not to make mistakes. And you certainly don't want to get caught in a lie when you were under oath, when you said a different statement. You, sir, just have a problem being truthful. You have a problem dealing with other people responsibly. The way you deal with issues is to assault. You use violence. No, sir, you have a rich history of doing that. You were pleaded guilty to two assaults. You pleaded guilty under oath that you tried to lie about a little while ago. Then this court has found sufficient evidence that you committed assault while on probation for assault. You are going to be held accountable. It's something you don't like, being held accountable for your mistakes, but we all are. We all are. And is there anything else you want to add?
I just want to say, Judge Steve, first of all, listen, please listen. I mean, you saying about how the way it was when I never had my father, and I didn't have nobody to help raise me and stuff like that. But that's
it's
what I'm trying to say.
Life's fault.
I never assaulted that girl.
Yeah. Let me ask you this.
And that's
How many misdemeanor convictions do you have?
Probably about two.
Sir?
I don't know. Probably about 2 or 3.
Wait, this is your life. This is your life. Nobody knows better than you. You don't know how many misdemeanor convictions you have had?
I probably had about 2 or 3 of them. I don't know.
All right. Let's see. It starts off in 2009. Illegal possession of marijuana, you were put on probation and then that was revoked. Criminal trespass in 2010, 30 days in jail for that. Illegal possession of marijuana in 2010, 30 days in jail for that. 2014, failure to identify, 30 days in jail for that. 2014, evading arrest and detention, 30 days in jail for that. 2014, resisting arrest, 30 days in jail for that. 2016, failure to identify, 150 days in jail for that. 7. Resisting arrest and search in 2024, 120 days in jail for that. And assault causing bodily injury to a family member in 2020, 60 days in jail for that. What do we have? 9. You said 2? You know more about your life. You got 9 misdemeanor convictions. Plus, how many felony convictions do you have? Evading arrest or detention with a motor vehicle that you were on probation for in 2015, and that was revoked in 2018 because you couldn't stay on probation properly, and you were convicted of that. And that makes you a felon, which means you can't even get probation by a jury on anything. And now we have 2 more assaults of peace officers. You're looking me in the eye and trying to sell me with, I've only got 2 convictions and these are 10 plus 11, 12.
I'm just trying to look you in the eye and tell you that I'm not no criminal. I'm not a criminal.
12 convictions is a criminal, sir. You've got the wrong definition.
I wish I knew the law just a little bit better, and I'm gonna make sure I learn that law.
That's not the problem with you. It's following the law. It's your problem.
Hey, that's very looking. I mean,
I know. That's the problem with this. And people get assaulted. Police get bitten, and your statement is, I'm not doing
he said I
anything
hit
wrong.
the girl 5 times. Do it look like I hit her 5 times? First of all, I didn't hit her not 1 time.
Anything else?
Just these. Okay, if you're going to, I mean, can you give me more probation or something? But I don't want to. It's your court.
Anything else?
You want to do anyway, but at the same time.
No, this is a product of your actions, not mine, sir. You have proven to be not only a criminal, now 12 convictions, 12 convictions when you tried to sell it with just 2, but you're committing violent offenses. You're committing assaults. You're dangerous. And you get caught telling lies. Your way of dealing with it is to try to lie your way out of it.
I don't have to lie.
No, you don't. And that's the incredible thing about it. You do it anyway.
I didn't lie not 1 time.
You just said, I'm sorry, didn't you say I had 2 convictions? Didn't you say I had 2 convictions?
I only wanted to get out of jail.
Didn't you say that I wasn't guilty of biting these officers when we showed under oath you stated you were guilty?
I apologize to you for that. Can you please have mercy on me?
If I'm going to be fair with you.
You don't mind?
You know, you didn't show mercy on the police. You didn't show mercy to this lady.
I promise to follow with all my stipulations on probation.
All right.
I promise to get started my payments. I promise to do everything that I need.
You made those promises. I'm sorry, you made those promises when you were placed on probation that you didn't follow, so.
I was homeless, Judge Stevens. I didn't even have nowhere to go when I got out of jail. My mom was getting ready to die. She died, actually. You know, she filed lawsuits and stuff that I'm dealing with right now. That's why I did the labor report. Look, I was going through a bad state at the time when my probation officers was telling me to report. You know, I had just lost my mom. She was in the nursing home, first dying.
We have thousands of people on probation. 92% are successful. They have the same issues, sir, and they are able to take care of their business like they are responsible. And you just can't help but interrupt me, can you? You interrupt, that's what you do. You don't follow the rules of decorum. You don't follow the rules of law. You have it your way on your terms, and everybody else suffers. There is sufficient evidence supporting these First Amendment motions to revoke unadjudicated probation in each of these cases, to grant them by a preponderance of the evidence or greater in cause numbers 35195 and 35435. As allegations 1, 2, 3, 4, and 6 have been proven true by a preponderance of the evidence or greater, and the court finds there is evidence on allegation 1, the lesser included offense of assault is proven beyond a reasonable doubt to support these motions to revoke probation. They are granted. And your deferred or unadjudicated probations are revoked in each of these cases. In each of these cases, you pleaded guilty to assaults on a peace officer, something you attempted a little while ago to try to deny until we showed you that you had sworn under oath admitting to this. You pleaded guilty to those cases voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of those cases. Your sworn instruments, sworn documents admitting culpability in those crimes. That is enough to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of those 2 second-degree felonies, which puts you into a position of no less than 2 nor more than 20 years confinement in prison. I find you guilty beyond a reasonable doubt as your probations are revoked. and you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. And those two sentences shall run concurrently. All right. Anything else? Anything else from the defense? All right. We are in recess. Here is the evidence in this case. Okay. Anything else? Stay. What do we need? David Grove?
Yes, sir.
Are you ready on some things?
There's one chief judge here.
Come on up. Who is it?
Parker.
Cody Parker?
Parker is ready.
Come on up, please. Thank you. You're Mr. Parker? All right, 21-37758 is called. And Mr. Grove is coming up here. You are Cody Wayne Parker, correct? Okay, I see it. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, sir, this indictment alleges that on or about September 7th, 2019, in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you're charged with? Yes, sir. If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, you may be assessed a fine not to exceed $10,000. Do you understand? Yes, sir. Yes. Yes, sir. An agreement's been reached. You would be pleading guilty and placed on, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation, which can be up to 5 years in length. Restitution is owed in the amount of, is it $300?
That's correct, Your Honor.
To the complainant in this case. Is that your understanding? And there will be terms and conditions of probation normal and customary to this charge. If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Yes, understand it, discuss it with your attorney, or the contents true and correct? Yes. State's Exhibit 1 is tendered into evidence. Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. Yes, State's Exhibit 1, part of the record for all purposes. Is pre-sentence report waived here?
Yes, sir.
I am going to follow this agreement and find you, sir, pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt here. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement and you are hereby sentenced to confinement in the state jail for 2 years. That will be suspended. You were placed on regular probation for 5 years. And there will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow these. Yes. If you fail, your probation can be revoked and you can be sentenced up to 2 years in the state jail. And restitution is ordered in the amount of $300 to the complainant in this case. When can you pay that money back?
As soon as possible. I'm on disability, so I get paid once a month.
Okay, yeah, you get that paid as soon as possible, okay? And it has a lot to do with how long you're going to be on probation. You know what I mean? You get rewarded by doing well. Okay, we can shorten it. All right, please see the probation officer. Oh, she needs your fingerprint first. Thank you, sir.
You want one? Straight up and down in 95. Perfect. Don't have to press that hard. Give me 2 more, same from now.
Here, is this in here? Snap. Dior Frazier, please come forward. Then Erica Joseph will be next. She's in custody. Healer Maldonado, you'll be next. Okay, and then we'll take the lady in custody. Okay, you are Dior Elise Frazier.
Yes, sir.
And you were here with Mr. Grove. You were charged with the second-degree felony of assault on a peace officer. If convicted, you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Okay.
All right, this is announcement. What are we announcing?
Well, Judge, basically, I believe the prosecutor and I have worked out an agreement where this case will be dismissed against
What do you have to do?
She has to
go through
basically get in the Army, Navy, or one of the branches of the service. The case is supposed to be dismissed, and then if she is not entered into the service within 180 days, the DA at their discretion can come back and can be fined.
180 days from what date?
Well, and Your Honor,
When did that start?
There's a proposed agreement here by Mr. Groves, but I informed him that he'll have to present that to, it's essentially looks like a type of pretrial diversion. He'll have to present that to Mr. Canal upstairs for his approval if he's approving.
Okay, what do you want to do to this? Review it in 60 days?
Yes, sir. And I think that I think we're pretty.
All right, we'll
close
review it
to
in 60
getting
days.
done. Yes, sir.
Okay. Review in 60 days, get a resetting, please.
Sir.
Huh?
So review.
Review. You're going to come in and we're going to find out. Everybody's going to tell me what the status is on the case, what direction we're headed in.
Okay.
Okay. Please, and Erica Joseph is in jail. Keeler Maldonado, come on up. Mr. Maldonado, in 24 CR 2392, you're charged with the first-degree felony of aggravated robbery, sir. This is very serious. You are looking at up to life imprisonment, sir. Okay, how old are you?
18. Judge, what we have here, we have a plea bargain agreement, cap here, where Mr. Maldonado may plead to the court, and the court could give him probation or send him to TDC. I left him up until the very end. I said, do you want to take the plea, which would be a cap plea, or do you want to set the case for trial? And that's where we are right now.
Okay, what are we going to do?
Yes, sir. I was trying to see if I could get the first probation.
That's, you talk to him. That would be, there isn't, he's talking about a cap that gives me options, and that would be one of the options, but it would be up to the court to determine, but that would only be after you entered a plea of guilty and after a pre-sentence report was completed. Then we come together, I read the report, everybody adds any additional information they want me to consider, and then I make the most intelligent decision I can make with the information given to me. That's the way that works. The other side of the coin is you can go to and try it in front of a jury. Those are your options. So what are you going to do?
And I believe that Mr. Boyd has made a cap offer, but it is discretionary with court, whatever the court wants to do.
So what do you want to do?
And what I have tried to tell Mr. Maldonado is that the DA will not agree to either a deferred adjudication or regular probation. recommendation. The court can, and that's what the offer is.
Okay, so what do y'all want to do?
You want
Or
to,
try the case?
you want to try the case, and you want to go ahead and take the cap where the judge could give you probation or deferred adjudication probation, or he could,
Yeah.
but there's no guarantee that it will be a deferred adjudication or a regular probation. It's just, it could be. And this is the same offer we've had for a long time.
Yeah.
So we need to decide what you want to do. If you want to do it, we can do that today, or the judge can set your case for trial. And that's the other alternative, which I don't think he wants that, but it's the other alternative, I believe, Your Honor. So what do you want to do?
Don't sit for trial, so.
You want to go ahead and plead guilty to the judge and ask the judge to give you probation in some form, either regular probation or deferred adjudication probation. The judge will take care of that if the court would give it.
All right.
the time to do
There
that.
you go. We'll do that today, write it up, and then we'll have a pre-sentence report
Yes, sir.
prepared, which would take a few weeks, and then we'll all come back and put in whatever additional information you want me to consider, and then I'll make my choice, my decision.
Yes, sir.
And we'll move on with our lives. Okay, fix that. Erica Joseph is out. You just have a seat right there, sir, and he'll get back with you here. Thank you. Erica Joseph is next call. She's in jail, 18-29479. That's a motion to revoke unadjudicated probation. What are we going to do? You okay there, buddy?
Yes, sir.
All right.
Miss Joseph is on
Yes.
probation.
Then we have a motion to revoke probation.
She has been given an offer, a camp offer of friend. I'm sorry,
Of 8 months state jail.
8 months state jail. She also is on a state jail caseload. What she tells me, she does not want to take any kind of a plea bargain.
Okay.
She wants to let the court leave her on probation.
Well, yeah, that may be what she wants, but it'll be the court's decision based upon
Yes,
the
sir.
evidence. There's a motion to revoke unadjudicated probation. Are y'all ready to move today?
It's all administrative, Your Honor.
Showed the presence, failing to abstain. Okay, what do y'all want to do today?
You want to ask the judge to leave you on probation?
Yes, sir.
You gotta be pleading guilty. You gotta plead true to this first, right? I mean, we gotta go through this hearing first. Now, y'all are going to the sentencing phase. Well, first of all, she's presumed innocent. There's a motion pending, and this has to be proven. Then we go to the step on what happens if it's proven true.
Judge, it's my understanding that if she wishes to plead unfree and wishes to stay on probation, she has that option. So that's what I think she wants to do.
Is that right?
Plead true. But to plead
Okay,
unfree.
have a seat. Let's go. We'll work on this. We'll do this. It's contested. We'll work on it, and
Can we take her formal, please, sir? Just so that we can.
yeah, I'm about to do that.
Okay.
I'll do that, but everybody have seats, and we'll go from there. All right, 18-29479 is called the State of Texas versus Erica Marie Joseph. That's you, ma'am?
Yes, sir.
Present with Mr. Grove, your attorney, and the state's attorney. There is a motion to revoke unadjudicated probation that has been filed as of April 11th of this year. Does the defendant waive a formal reading of this motion to revoke probation? Mr. Grove, can we proceed in summary?
Yes, Your Honor.
And raise your right hand, ma'am. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. In summary, this motion to revoke unadjudicated probation states that on September 24th, 2018, in this court, you were placed on 5 years deferred or unadjudicated probation for the crime of injury to a child. And that was the indictment which alleged that you on or about February 2018 in Jefferson County, Texas, recklessly causing bodily injury to a child not older than 14 years of age by throwing a can at or near the child, striking the child in the head against the peace and dignity by the state. Is all of that true?
Yes, sir.
All right. And allegation number one states you provided a urine sample to the probation office on or about March 13th, 2025, which showed the presence of benzodiazepines and tetrahydrocannabinol, which are violations of condition 10 of your deferred probation order. And the condition 10 states do not use or possess any drug, use of, possession of, and prescriptions for any and all medications must be immediately disclosed to your probation officer. So do not use or possess any drug. You understand what you're charged with in allegation one. Is that true or untrue? Is this allegation true or untrue? Are you pleading true voluntarily and because it is true?
Yes, sir.
Do you understand that a plea of true to one or more violations of probation, that would be enough to grant the motion to revoke probation? A voluntary and knowingly made plea of true is enough to grant a motion to revoke probation. Your probation could be revoked. You could now be found guilty of this state jail felony and sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Allegation number two states you failed to abstain from the use of any and all intoxicating substances, including alcohol, in that you provided a urine sample on or about March 13th, 2025, which showed the presence of alcohol. So apparently that same test, that same analysis or sample that you gave, which showed drugs, also had alcohol in your system. And that is what they're alleging was a violation in allegation two. Is that true?
Yes.
Are you pleading true to that allegation voluntarily and because it is true as it is alleged?
Yes.
And you understand the consequences that can happen of voluntary and knowingly pleaded true to one or more violations of probation? That's all it takes to grant a motion to revoke probation by a preponderance of the evidence or greater. Your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment we described. Knowing that, you insist on pleading true to this today.
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Finally, allegation three states you failed to pay court costs and assessed fees as directed. As of March 18th, 2025, you were in arrears $2,738, which is in condition 28 of your deferred or adjudication order. And that states pay the amounts shown in this order. And that is a fine of $500, supervisory fees of $60 a month, attorney's fees $600, Crime Stoppers fees $50, post-sentence investigation fee $500. It all ends up adding up. But anyway, were you indeed in arrears at that time?
Yes.
Were you able to pay these?
No, sir. I work at KFC. I'm a shift manager. And I pay child support to my children because since this has happened, my children have been removed from me. And my son is now 19.
Yes, ma'am.
Getting him into college and stuff, trying to get him into, doing something positive with his life because he lost his father at the time that this happened.
Okay.
And I was going through depression.
Yes, ma'am.
Anxiety and depression.
Okay. But what you're saying is, you okay there, David? All right. You're in arrears on these payment requirements, but
yes,
you would have paid them had you had the money.
Yes, sir.
But you didn't have the money.
No,
Okay. Well, then we're not going to enter a plea on that one. Okay. Because nobody goes to prison for being poor. Okay. You got to pay what you can.
Yes, sir.
This isn't debtor's prison. Those are bad things from history, and we don't like to even think about that. And America is not that way. All right. But you've got allegations 1 and 2 here that you need to deal with. And you're talking about all your responsibilities. I can appreciate that. But you're talking about drugs and alcohol that have nothing to do with responsible behavior, especially when you have so much to lose here by following the rules responsibly, or if you fail to follow the rules. And that means not using drugs or any of the children at all in your home?
No, sir.
No.
They're all with their paternal grandmother.
Okay. Is this lady? Or is this the other?
That was the last time.
Okay.
I'll get you.
Yes, if you can. All right. What do we want to do?
I have the probation officer here if you want to hear some testimony about.
Well, I'm curious what y'all want first, and then she has 138 days credit. Okay. What do you want? Do y'all want to call somebody and to the stand, or do you have any ideas where y'all stand on this? I think David Grove, you're going to want to continue her on probation.
Yes, sure.
I presume.
That's
Okay.
what she indicated.
Okay. What's the state asking?
Same for 8 months state jail. We've had several issues with her in the past. She's been to Safe P. She's been to Safe P Relapse. She's done the drop program. She had outpatient help as part of Spindletop, and she continues to test positive on drugs. So at this point, I believe that probation has exhausted all efforts on this defendant. And we think 8 months state jail is fair, considering her lack of ability to stop her drug use and her alcohol use, and the fact and the underlying offense of this case.
Okay. You want to call somebody to the stand then?
Yeah,
Okay,
we
go
would
ahead.
call Dominique Mayfield.
Dominic Mayfield, please come forward. Hey, raise your right hand. You solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you, ma'am. Go ahead. Have a seat. Stand by. Let me look at one thing here. You've been the probation officer for this lady?
Yes, sir.
Because I was looking at Douglas Gregory was a probation officer at one time.
Yeah, she had completed the safety continuum and then she was placed on the MHI, which is the mental health initiative caseload.
Okay. Stand by. Stand by. Okay, Ms. Mayfield, is your witness? Go ahead.
Are you currently the probation officer of Erica Joseph?
Yes,
How long have you been her probation officer?
about a year.
Is she in the courtroom today?
Yes.
Could you point at her and identify an item of clothing that she's wearing?
Yeah, she's in orange tights.
May the record reflect she's identified the defendant.
Yes, it will.
Has Miss Joseph had more than one administrative hearing?
Previously, before I had it.
How many administrative hearings has she had?
I'm counting 3.
Yes.
Going back to 2022, what this court shows is on June 21st of 2022, it was alleged that she had tested positive for drugs, cocaine, benzodiazepines, and that it stated she tested positive for illegal drug use on 5 separate occasions while under supervision. And this was before June 21st of 2022. Again, the defendant had been on probation since September 24th of 2018. So this was 4 years into her probation. She admits she has issues with substance abuse, minimizes though the extent to which she uses. The defendant has attempted to assist her in overcoming her addictions by referring her to Spindletop, ATAR, but she has refused to actively participate. Defendant is also a participant in Spindletop Forensics Program, and her caseworker concurs with this officer that the defendant is in need of a more restricted inpatient program. So they were recommending entering into completing the special needs substance abuse safe P and extending the current probation for a period of 12 months. And this was approved by the court on 6/20, looks like 6/27 of 2022. Did you go through with that program? Yeah,
Yes, sir.
you did that. Okay. So that was in June of 2022. Then in May 29th of last year, I get another administrative hearing from Ms. Joseph. And this one states that the defendant tested positive after the Safe P program for THC and alcohol. And this would have been on before the most recent, the one we're dealing with now, the tetrahydrocannabinol and marijuana again. So you had completed Safe P, then you were sent to Safe P residential aftercare at the Melton Center on June of 23, successfully completed that. Then placed on the Safe P outpatient on 2023, and you completed that on April 22nd. You have struggled, it stated back then, with substances. And you were also testing positive for alcohol. And you reconnected with Spindletop to resume your mental health medications and thought that would help you. And this states you do have the tools to stay sober, but you don't have the commitment to be successful. So it was recommended that you enter and complete drug rehabilitation, the DROP program, and placement in the mental health initiative, which this court granted on June of 2024. Did you do that? Yeah,
I'm not aware of what this is.
and I granted that. What happened on that?
The drop program is when she would be placed on the color and she would come in, she would call the
And that was done.
Okay, yeah, I know that I did that after I came back from Safe P.
That was the second thing. That was the second set of help that we gave to you, you know.
Oh, I thought that was just part of the aftercare from Safe P.
No, we had a hearing on this and I didn't order a revocation or anything like that because I'm trying to give you all the help you can.
Yes, sir.
Okay, now we've got a third situation. Miss Mayfield's administrative hearing shows up to my desk on March 18th. This is the third.
Yes, sir.
And this states that you tested positive for benzodiazepines and THC and failed to abstain from alcohol. You have struggled to come into compliance and you have been consistent in the illegal drug use. Hold on. The department has attempted to assist the defendant in living a clean and sober lifestyle, and they have. They're doing their part. In addition, while on the mental health initiative caseload, in conjunction with Spindletop, you had been receiving outpatient substance abuse programming. Yet you continue to use illegal drugs. The officer believes this department and the court have exhausted all available resources at their disposal to aid in your success, as you lack the ability and or desire to be successful on probation. It should also be noted that your probation was continued for 2 more years, which this expires in September. And the recommendation was to file a motion to revoke probation, which you did not agree with. this court followed the recommendation of the probation officer. And then this motion to revoke unadjudicated probation was filed on April 11th of this year, which alleges what you have pleaded true to in allegations 1 and 2. And that's where we are. I think it boils down to this, everybody. Has she had more than enough fair opportunities to fix her problems or not?
I turned myself in to the officer.
I know what we want you to do is refrain from illegal drugs and alcohol, ma'am.
Yes, sir. So I did two months in county so far.
You have 138 days credit.
Okay, yes, sir. Thank you.
But remember, this is a state jail felony. The minimum punishment is 180 days, 6 months. And this is 138 days showing, which is, a little over 3 months,
Yes, sir.
3.5 months. But you're at the minimum, see that you're still 42 days away from a minimum sentence. Anyway. Are any children at home?
No, sir, they're not at home with me, but I'm helping my son get into LIT right now.
How you doing that?
Filing for his FAFSA, and he's going through the Pittsburgh Foundation, where they're helping him also. And he's at LIT right now, and I need to file for his rest of his financial aid assistance so that he can continue his.
All of this is good. You're helping your son. That's what a responsible parent is.
Yes.
But also a responsible parent, the most important thing is being a role model. You have to set an example. Why shouldn't he use drugs? You're doing it. Where's the role modeling?
I don't do drugs around my son. I don't really.
That is the most pathetic thing I think I've ever heard.
Yes, sir.
That really almost tops the chart of the most weird things I could hear from someone. You really think just using illegally drugs in secret is the right thing?
No, sir. I use my thought stoppers also, to not, continue.
You're taking, ma'am, this is the 3rd time you've tested positive.
Yes, sir.
But I think you're missing the boat here. This is your life. You're the role model. And don't think your children can't see problems. But you got to admit and face the fact you're making consistently the wrong choice. And we've done all we can to help you, I believe. And you're still, these are crimes.
Yes, sir.
On the court's watch. My goodness.
It's one more thing that I signed for to do through the probation, if you don't mind, Your Honor.
Go ahead. What?
It's the DTS program where I go back on colors and I go to classes at the probation office. And
So how would that help you?
Because I'm gonna go to my meetings and I have a new sponsor that I met since being incarcerated at the JC at the jailhouse. She's with Keeping It Simple at St. Anne's Catholic Church, and I wanna she's gonna be my sponsor. I met her like about 3 weeks ago.
Okay, so what's different? We've been helping you and getting you in all these substance abuse programs, and you have consistently failed them and continue to misuse.
Yes, sir. Just ask that you try one more time with me, please, Your Honor. Please, Your Honor.
How would this be different? How would the 4th time be different?
I'm trying to build a better relationship with my daughters and my son, and I will complete this program.
When did that come about?
Actually, my son and my daughters, recently when I came home from safety.
When? Give me a date.
Say, September of September the 4th on his birthday, September the 4th of 2024.
But you're testing positive in March. What is this year? Just a few, you're testing positive. Anyway, after that.
Yes, sir.
So that is, there's nothing there's nothing that has occurred with his situation that made you change. Okay, let's just get it clear.
I just asked for one more chance, Your Honor. Just one more chance to get it right, please, sir. And I will get it right, and I won't let this occur again. You won't see my face again in here.
I wish I had $1 every time I heard that one.
Yes, sir. I understand that you've heard that before.
But you made a promise when you first started that you would. Let me read it. It is eloquent.
If I may, Your Honor.
Hold on, let me read this.
Okay.
This was when you were placed on probation initially, back in 2018. You made a deal with me and you signed it right here. I have received a copy of this probation order. I agree to follow all conditions imposed upon me, and I know that this community supervision can be revoked for any violation. I will remain in the legal custody of the District Court of Jefferson County, Texas, and I hereby waive extradition if I am charged with a violation and am arrested in another state. I agree to follow all conditions imposed. How many times did you break that promise?
A few times.
4 that I know of. And you're asking here, let me hold your wallet, Judge. You can trust me? No, you made a promise there. You broke it in 22, gave you another chance. You promised all would be well. You broke it in 24. All would be well. And you broke it in 25. Which it's the same problems. Drugs and alcohol that we put you through all the programs. But it's not the programs that make the change, it's your will. It's your intestinal fortitude. And we can't force that. That has to be your choice. Okay. What's state asking for?
8 months state jail.
What do you say, David?
Judge, since Ms. Joseph asked to be reinstated on probation,
Yes.
I would defer to her on that.
What would a backup plan be? If you had, what would you request if the court decides not to grant the relief you're asking? In all fairness, you've got to see, I mean, I open the door for one, I open the door for everybody. Everybody is unique, but this is the 4th problem. It's the same problem. We've exhausted what we can do, and all her answer is give me another chance, which would be the 5th, which opens the door for everybody to get 5 chances. I don't like that. Everybody, you made a promise at the beginning.
Judge, I believe Ms. Joseph will request 180 days. Yes, sir. State jail. Is that correct?
Anything else? Would you like to say anything, Ms. Joseph? This is your life.
Your Honor, I'm just asking that you show mercy upon me at this time. Just so I can I just want to do a relationship with my kids and to show them that I can live sober and to do this and to do a sober lifestyle and to be happy being sober. I've been through a lot of depression. The father was murdered. I've lost a lot of family. While being on probation, sir, I've been through a lot of different changes in life, and I know that's a part of life.
Yeah,
And it's
yeah,
just
everybody
difficult.
does it. Everybody suffers.
Yes, sir.
This isn't a bed of roses. But we all have to deal with it in our own way.
Yes.
And wouldn't you agree you've had more than enough chances here to do?
Yes, sir.
It's a consistent pattern of the same mistake.
Yes.
I,
And I'm trying to go through safety and take my medicine and do better.
yes, ma'am.
I'm sorry, sir. I said safety. I meant spend the top.
Yes, ma'am.
Oh, goodness. I'm going through spend the top. I had a little, in between time, I've messed up a little bit, but I think that,
Messed up a little bit, those are crimes. Each of those are criminal acts.
yes, sir.
And we've got three sets of criminal acts since you were put on probation.
Yes.
Oh my goodness, it's just that's hard to ignore, and it's the same crime. But yeah, what you're just not accepting is that your life touches your family's life, and you're supposed to be a role model, and you can't expect your children not to do the same thing you do. You're setting a consistent example of committing drug crimes. And that's not good parenting.
That's true, sir.
All right. But it's your choice. You've decided this is more important than setting a good example for the children. That's got to change if you care about them.
I love my babies.
You gotta just don't talk the talk. You gotta walk the walk of responsible behavior. All right, I'm gonna find, if nothing further, there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by a preponderance of the evidence or greater, as allegations 1 and 2 have been proven true. And your deferred or unadjudicated probation is hereby revoked. In this case, earlier you pleaded guilty voluntarily. You were mentally confident to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt at your guilty plea hearing at the beginning. I now find you guilty beyond a reasonable doubt of the state jail felony of injury to a child. I am following, there is no agreement. You are hereby found guilty of the state jail felony, and you are hereby sentenced to confinement in the state jail for more. And you failed in each of those occasions.
Have you?
Well, you gotta do better, if not for yourself, for the family you keep claiming you care for. Nobody lives alone. We're not on this planet alone. We touch other people's lives, especially our family. And the greatest gift is a good example, a role model. Greatest gift a parent can give, because your children are going to do what you do, and you're not setting good examples. You have to do better if you really love your children like you say you do. You got to commit to that. And every day is a challenge. But we all are required to do it, or else we get held responsible. Are you able to do it? Are you able to?
Yes, sir, I am.
Well, then do it. If not just for yourself, for the children you care about. All right. Good luck.
Thank you.
Yes, ma'am. Anything else?
David's.
Maldonado? Yeah, Caitlin. Caitlin.
All right, thank you.
Judge Maldonado,
What do we
believe
wanna
Mr.
do
Grove
on
and I
this
were,
date?
if we could reset it 3 weeks. I
got
know
it.
we've got it worked out, but we'll.
All right, it'll be reset 3 weeks, search. Mr. Grove will get a resetting for you. Anything else today?
Nothing.
If not, we're in recess. Hey, have a nice weekend, everybody. See you Monday. Promise? Okay, it's a date.
On July 16th. So right now I have the total rent to retain is $845.50, costs of $242.00 for a total of $1,087.50.
All right. Okay, Miss Carroll, how are you intending on getting that paid?
I am going to pay. I can do 200 tomorrow. My son is supposed to give me some rent money, so I can maybe do another 200 by Monday. And then I will pay the rest and July's rent on the 3rd when I get Social Security.
When you get Social Security? Okay.
Yeah.
I gotcha. So that's kind of the plan there. All right, so here's what I'm gonna do. And I'll explain why I'm gonna do it. I'm gonna issue a judgment for possession, finding no tribal issue for the $1,087.50. And then you would have until no writ before the 7th of July.
To get everything paid by the 7th of July.
Yes, everything paid by the 7th of July. That way, if your plan works out where you get your Social Security check on the 3rd, get everything paid, you're all set.
Okay. All right.
So, sounds good?
Yeah. So should I go ahead and try and just make those payments that I talked about to begin with, or just pay it all on the 3rd?
You mean pay the 200 and then the other amount? Oh,
Yeah.
Here's what I would do. If you've got the 200, get it paid.
Okay.
Because you know how
All
it
right.
is. If you've got the 200 in your hand, something comes up, right?
Right. Exactly. Yeah.
So
Yeah.
just do it, get it paid, and then that way, once your Social Security check comes in, you can get everything taken care of.
Okay. All right.
All right. Ms. Carroll.
Thank you, Your Honor.
Sorry,
And
Your
it's a
Honor.
default. Go ahead, Ms. Samantha.
Yes, Your Honor. I was gonna ask you if it was gonna be a default as to Linda. And then I want to just clarify that the total balance is $1,087.50.
Yes, the judgment amount is $1,087.50. And yes, it would be a default as to the non-appearing party.
Thank you, Your Honor.
Okay. So do I need
All
to
right.
come back to court or no?
Why, you want to come back and see me or not?
I mean, I like you, so, you know, but
Well, thank you for saying that. I don't get that a lot. All right. No, you're all set. You don't need to come back. Just get everything
okay,
paid.
thank you.
Okay? Then
All
you'll be
right,
all
thank you.
set.
All right.
Ms.
Have a
Carroll,
good
have
day.
a great weekend.
You too.
Arbor Woods versus Melissa Cole.
Casey Matson on behalf of the plaintiff.
She's here.
Why am I canning?
Got it. Hello.
Hello,
What's your name?
Melissa Cole.
All right. And where are we on this case?
Well, today,
Hold on a moment. Let me get the
Oh.
balance. No, it's okay. It's okay. What's the balance currently?
Your Honor, the total rent to retain is $2,839.00. Cost of $186.00 for a total of $3,025.10.
What were you gonna say?
so, well, I originally was supposed to pay something on it today. because I'm like literally just getting back to work. I was off for 2 months. And I don't know what happened.
What's wrong? What do you mean? You don't know what happened?
About work. Well, I was wrongfully terminated, so they had to bring me back once they did their investigation.
Okay.
And so when I came back, they had to put me back in the system. So they were having to manually put in my hours every day. And some reason over like 60 out of 80 hours didn't get put in. So this is my paycheck from today. I brought it just in case you can see that it's not even half of what I usually get. So I don't have a payment today. I did put in with DHS. I have a tracking number. And so I'm just kind of waiting to hear back from them because I originally put in, but they said that they didn't get my notice. And so I spoke with the liaison. I believe her name was Amy, and I told her which I sent in, and she said it was correct. It took me a few days to get in touch with somebody from DHS, but when I did talk to someone, she said that I had, since the time had lapsed, I had to put in another application. So I did that, and at this point, I'm just
How many
waiting.
people are in your house?
Me, just me and my 2 sons.
Okay, so the most that's gonna net you if they come through with $620 of the little over 3,000 that you have.
Yeah, see, yeah, the issue isn't that I can't pay it.
No, I got you. I got you. And I mean, what you're telling me is they messed up your check. And then, so let me ask you this, the next time you're scheduled to be paid is when?
July 11th.
Okay. All right. So you're scheduled to be paid on the 11th. What are they going, and let's presume that they actually get your hours right this time, right? What are they going to do with the shortage of hours from?
Oh, that's what I'm waiting on. If they don't get back with me, the payroll said that they'll probably contact me Monday about getting a check written out.
Okay, so to cover that.
Yeah,
so
what
that-
was missing from, yeah.
Okay, and because what you had indicated is you were gonna pay 2,000.
Yeah.
Right.
Yes.
Okay.
But worst case scenario, I could pay the full balance, past balance, by July 11th, if I
Okay.
don't get help with DHS.
Gotcha. Okay, so here's what I'm gonna do, and I thought that's what you were gonna say to me, so you anticipated my question. All right. I'm gonna, since we're coming down to the end of the month, so that we're not clicking July rent in this, okay? I'm gonna issue a judgment for possession, finding no tribal issue after a hearing. Okay, for the total amount of $3,025.10. Okay. Normally, you would have until the 7th to get that paid. Over the objection of plaintiff, I'm going to give you to the 11th, that Friday, to get paid.
Thank you.
Okay, because if they shorted you on that one, then it's gonna take that next check for you to try to clear everything.
Yeah.
And in between that time, you gotta eat.
I
Okay,
appreciate that.
okay, so that's what I'm gonna do. I'm gonna issue that judgment. Okay?
All right, thank you.
And that, just so that we're clear, that doesn't include your July.
No,
Got
it does not.
Okay,
Okay.
okay.
All righty, thank you.
Thank you. Have a good weekend.
Yeah.
Harbor Woods versus David McLeod. Okay. Did.
They go to.
Oh, yeah, come on up.
And she's my realtor slash lawyer slash health assistant.
Just realtor and help.
Huh?
Just realtor and help.
This realtor and health. Okay. I noticed when I called the case that you didn't really hear me call your name.
Yeah,
You
I'm
need
pretty
some-
deaf,
You
I'm
need some
sorry.
equipment to help you?
Is there a speaker?
Well, hold on. Let's try this so that you can.
Yeah, I get hearing aids and I lose them. Thank you so much. All right.
Oh.
Thank you.
You got it?
Yeah, that's great. I wish I had these real life. This is
Your eyes got real big when all of a sudden it's like you could hear me.
That's right.
Okay, can you tell me your name?
Dave McLeod, 10/9/49. I'm 75, live at 1987 Nolan Bend, been there 20 years.
All right. Okay. How much is owing on this account?
I'm sorry?
I'm asking the attorney.
Oh, okay.
Your Honor, what's the case number on this one?
Case number on this one is, it ends in 2095. It's 251C 2095 LT.
One second, Your Honor.
All right. Because he came in security.
Security told him it was in C. He sat outside of C. Even though it was a Zoom hearing.
Oh,
We didn't know.
okay. So, counsel, part of the confusion may be that, and I don't know if you heard my staff, on the 13th, there was a judgment issued.
Yeah.
That may have been where it was left off for you.
Right.
And then what we found out later, it was a Zoom hearing. He had come down to the court.
Right.
Sat outside the court, because
Right.
that's where security told him. Bizarre for them to do that, but they never told us he was out there.
Well, we were sitting outside and door was locked, and
Yes.
we'd let them know, and they said, "Oh, we're sorry that everybody had left." So they made a judgment against us. So we didn't even have a chance. So you want me to tell my side, or you got questions?
Hold on. That's okay.
Okay.
That's all right.
No, I don't mean about the appearance, but what's going on with the eviction.
Don't, hold on one moment.
Appreciate that.
So we, on that date, the 13th, there was a judgment issued for $974.
Right.
Yes, Your
All
Honor.
right. Okay, so let me ask you this. Go ahead, I'm sorry.
I don't believe our office got notice of this hearing, so I don't have a current ledger. I would
Got it.
assume that the balance is still $974, since that
There
judgment.
might be a late fee or something else in there if he hasn't paid.
Yes, correct.
Okay,
But it would be around the same, since
same
it's
amount.
in,
Oh, okay. That's what I was figuring that we were gonna be. All right. So for right now, we're gonna say you owe $974.
Yeah. I tried to call them to make a partial payment to ease it till we could come up with something. They hung up on me.
Who?
The manager in the office.
Okay.
So I don't know. We've got on running feud with that place for years. Last year they lost one of my checks because it's night deposit, and they claimed they didn't get it. Well, it takes 6 months or more to track down a money order. So recently, since I got a lawsuit against them, they claimed it again that I lost it. So I paid last year twice on 1 month, and they want me to do it again. So my health is bad. We're selling the place, moving. I've got stuff in the driveway for an estate sale. They're mad about that. And just to keep up with my money, I sold my lawnmower. The woman said, "Oh, I could borrow it back." Well, that's been tough. But anyway, so I'm caught in the middle of all this stuff.
Okay.
And hopefully we got people looking. We're going to sell it soon. But
okay,
I'll even pay for the new people coming in a month just to satisfy them.
Okay, let me ask you this.
Yeah.
If it's $974, when do you think you can get that paid?
Probably when we sell. I've got some money coming in SSS in July,
Okay, so when do you get that?
Toward the end of the month. So,
Oh, okay, so your check comes at the end of the month.
yeah, it's all alphabetical. So.
How does M end up in a N? Anyway, never mind.
Okay.
So what happened to if you get your check at the end of the month, what happened to the one for this month?
Paid for health bills. I've been going without teeth for getting them made at U of M Dental School. And the insurance, won't pay for implants. I end up having to pay, and they won't give you the teeth until you pay. So these are temporary, and I'll be talking. They may flip out while I'm talking to you, or they don't work they don't work for eating.
Okay.
And the bills I had a fall. I didn't tell you that. I had a fall on the ice. That's why I'm suing them. They don't keep the ice clear mailboxes. And I went up December 23rd to get the mail, and they were sheer black ice. I didn't see it. Got out of my car to walk up the wheelchair ramp, and boom, I can show you a picture, a big knot on my head, knocked me out. And people came to get their mail, found me there, thought I was dead, came up and kicked me. And so they helped me into my car, took me home, which is about 4 doors down, and called the ambulance to come and take me away, and had all kinds of tests. So I've still got balance problems. It takes me an hour to get dressed, sometimes a half hour just to tie my shoes.
All right, let's do this. So if I told you had to come up, because I don't know when the sale's gonna happen. Right? So if I told you had to get this $974 paid, when can you do that?
Let's say by the 20th.
Of
July. Yeah.
Okay, because that's when your check comes in.
Yeah.
Your Honor.
Okay. Yes, go ahead.
Your Honor, there would be an additional $30 late fee at this point.
Okay.
So that's $1,000.
Yeah, if we add 30 to that, that's what, $1,004.
All right.
Okay. Okay, so let's try to get this resolved.
Yeah. Well, hopefully we'll have a buyer by then. So
Right.
and then I can get it done sooner. Yeah.
Okay, so here's what I'm gonna do. So that July doesn't kick into what's owed.
Okay.
Right? At this point.
I appreciate
that. Doesn't mean that you still don't owe July.
Oh, no.
But what I'm gonna do is
before you can sell, I got to clear that out. Yeah.
Right. So what I'm gonna do is I'm gonna issue a judgment for possession. I'm gonna find no tribal issue after hearing.
Okay.
That total judgment amount is going to be, I think it's the even number, so $1,004.
Okay.
Okay.
Fair enough.
And you don't get any money until that check comes on the 20th.
No.
Correct? You don't have anything.
No.
Okay. All right. So I know this is way over objection of plaintiff, but I'm gonna.
Yeah, my wife died a year ago, so I've lost half my income. So.
Okay. Writ date the 20th.
Okay.
When he gets his SSI check. So you can get that. If your home hasn't sold yet and you haven't moved, I'm giving you till that date when your check comes in to get this paid.
Okay.
You're still gonna owe July.
Right.
Right, but this will at least get clarified.
Yeah. All right, very good. I appreciate your help, and thanks for listening.
Oh, absolutely.
It's all true, so help me God, or strike me. And thank you for these. I tell you, I want to appear for home. Thank you, sir.
All right. You guys take care.
All right, that's it.
That's it.
God bless you guys. Have a great weekend.
Your Honor, you would like me to submit a new judgment for that, correct?
Yes, please, if you would. I think what we'll do is we'll just do an amended judgment with a new date, the new amount.
Thank you, Your Honor.
Thank you. Arbor Woods versus David Pitchford Jr. Oh, and also Helen Cummings.
Judge Simpson.
Hello, Ms.
How
Cummings.
are
How are you?
I'm okay, how are you?
All right. And is Mr. Pitchford good?
No, my son doesn't stay there with me anymore.
Okay.
I had to get.
That's okay. I'd rather talk to you.
Thank you.
All right. Okay. What's owing on this account?
Your Honor, the rent to retain is $84.83. court costs of $242.00, for a total of $326.83. That is primarily the court costs and then a late fee.
Okay, so what's the total amount? I'm sorry.
The total amount is $326.83.
Okay. All right.
Well, Judge Simpson, when I came to court on Zoom the 13th,
I remember because you were yelling at
I'm sorry.
No.
I got excited
I know you did.
because I'm on a fixed income as well. I've never been late with my lot rent. I've been there for 10 years. When we were without a site manager, we have one now, but at the time, Dana had said that she would dismiss the late charges because I've never been late and she could only do it one time.
Okay.
Well, by the time I went into the system to pay it, it was higher than what I had in my account. And what started my late is the system will come up error. So you can't get in to make the payment. I'm going in trying to talk to someone, but without a site manager, you get the runaround.
Okay, hold on. Let's try to see what we can do here. Counsel, how much of that was rent that was owed? Well, it's not really going to be rent. It's going to be late fees, right?
Your Honor, there was a late fee in May that was waived, $55. But since that date, there has been late fees for June that have accrued.
Okay. Okay, so see how we can do this. All right. But how much is your monthly rent?
My rent runs like $657 plus the sewage and the water. I pay anywhere from $720 some because they make you pay a $10 check fee, blah, blah, blah.
Gotcha. Okay, so you're about 720, let's say 725 is your monthly rent.
Every month.
Every month. Yeah. Okay. So what we really have here are sort of an accumulation of, well, let me ask this. Counsel, in June, well, this month she's paid her rent or she paid, did she?
Your Honor, she made a payment on the June 7th of $790.74. So the only remaining balance is $84.83, which is comprised of the late fees.
Late fees. Okay. Okay.
Your Honor, I paid the rent on 6/5, not the 7th.
Okay, Ms. Cummings.
I mean, what I'm saying
no,
it's
just listen.
When you're late.
Yeah.
I just want to cry. I'm on a big.
Don't you start crying.
I'm raising a granddaughter. She's 13, going to the 9th grade.
Ms. Cummings.
Yeah.
All right. I'll tell you what.
Yeah.
If you feel like you want to yell, go ahead. I'll let you.
I don't.
No, I'll stop everything and let you go ahead.
I don't want to yell. I want to cry because I'm on a fixed income.
Okay. And let's do it this way, Ms. Cummings.
Okay.
You're not going to be in jeopardy of losing your housing. That's why what I wanted to make sure what I was looking at. So I'm looking at basically $85, which is really late fees of some type, right? And then I've got court costs. Okay, so what I'm trying to do and what I need to know from you is how can you, I know it'll be tight, okay, but you got to stay with me here.
Okay.
And that is how can you get this paid?
Sell dinners. No, I'm just saying I should.
All right, I'm gonna ask the question a different way. Okay. When you get your check on what?
The 3rd of it.
The 3rd.
Yes.
Okay. So if you had to pay an additional amount, each month. What do you think you can pull out of that? You're not sure, are you?
I'm not because
Okay.
I pay on.
Hey, okay, all right, hold on a moment. Ms. Bauer,
Yes, Your Honor.
through legal services magic, I don't know what that is, because I don't know what you guys do half the time. We need to find, I need to find $326 for Ms.
I was going to ask if, and I just heard the tail end, I don't know what the situation is, but what's your name?
Helen,
Is Helen, have you contacted Housing Bureau for Seniors?
no.
There's some skip money, I've been told, that might be accessible, if you're a senior.
Hey, I'm 69.
No, she's not. She just pretends to be a senior. All right. Oh,
So I think if you contacted Housing Bureau for Seniors and told them that you needed SCIP, SCIP money, that they might be able to help you. And if they can't, you can do an intake with legal services and then.
let me do this here. Okay. Counsel, if you're looking at her ledger, she gets her rent, she pays her rent every month. Because I believe what Ms. Cummings is saying. No, don't you start yelling at me.
I won't do.
Don't you start, I'm not questioning you.
Okay.
I'm just trying to verify.
Okay.
Your Honor, it does appear that she is pretty regular with her monthly rental payments.
Got it. Okay. So I'm gonna take a chance on you. Okay. Rather than issue the judgment, I'm gonna adjourn out to my next day.
Okay.
I'm gonna let them give you the information for Housing Bureau for Seniors, see if you can come up with this 326.83.
Okay.
Because my next date is the 11th. Okay. So I want you to pay your July rent on time.
I
Pay whatever. I know.
Okay.
I wasn't questioning you. I'm just saying, pay your July rent on time.
Okay.
And let's see if we can find the 326.
Okay.
How's that sound?
That sounds good to me.
All right. So I'm going to adjourn this out to July 11th, 2025 at 2 p.m.
Okay.
Okay.
I thank you.
Will that work for you?
Sure will.
Okay. So they'll give you that information.
Okay.
And you know what? The greatest thing about this whole thing is you get to come back and see me.
I know.
All right.
Everybody gets that pleasure. Thank you.
Now, when she said, I know she lives this way, so I looked to see if there was any irony in it. I didn't see any.
Yeah. And that I'm adjourning it over plaintiff's objection so that it's clear.
Thank you, Your
All
Honor.
right. Take care, Ms. Cummings. Court does call the case of Arbor Woods versus Heather Randall. Okay, yep, she's coming up. Hello. Your name?
Heather Randall.
All right, and where are we with her case?
Your Honor, I have rent to retain of $3,733.75, cost of $186.00 for a total of $3,919.75. At the last hearing, she did indicate that she was going to make some payments on the 20th and the 27th, and my client has not received any payments from her.
And what do you want to tell me?
When we spoke the last Zoom hearing, I told you I was just out of the hospital. I had surgery the day before. I didn't realize the dates. I'd been out of work for about 2.5 weeks from a surgery and then subsequent hospitalization. I just got my check today, so I have $600 to pay today.
Okay.
I don't know where the $1,200 came from. I don't know why I said that.
You said oh no, it's okay. I mean, but you said you were going to pay
Right.
$1,200 on the 20th and then $600 on the 27th.
Yeah, and I can't explain why I said that. I don't know. I had nothing in my account. I hadn't worked. It's been
Um,
ongoing for about 5 years. So
Gotcha. Okay, so how are you gonna,
I've contacted, I did my state emergency relief. I have a phone interview on the 2nd. I contacted Hawk. I am waiting for someone to return my call again. I just got information about veteran services. My son lives with me and he's a veteran.
okay,
Yeah, and I
So-
didn't know about that.
pardon?
I didn't know
Oh,
what services.
okay, so your son lives with you, he's a vet.
Yeah.
And you guys didn't contact anything having to do with veteran services?
No, he's having some mental issues, some mental health concerns, and he doesn't feel that he needs any help.
Okay.
Yeah,
All right, so let me ask you this. If he's not cooperative in that process, how do you think you're gonna, how, have you thought about how you'd access VA? I mean,
well, I'm going to call them myself and see if there's something I can do.
see if there's something you can do.
Yes.
Okay.
So far, I've not had a lot of luck dealing with VA on his behalf, but maybe.
Right, I mean, they're gonna need
Because he is,
him.
right,
to-
and that's the concern, but I'm willing to try.
Okay.
I did just contact United Way as well. My cousin told me about that. And
So here's what I'm gonna do,
Sure.
man. And part of this, I'm gonna do over the objection of plaintiff. I'm gonna issue a judgment for possession because I'm coming down to the end of the month and I don't want July to click in. For the $3,919.75. So I'll issue that judgment. And then I'm going to also, over the objection of plaintiff, extend this to July 11th.
Okay.
2025. So the important thing about that is that when you get in touch with the VA,
Mhm.
let them know that that's
I will.
your date.
Yep.
Also, you said you had called Hawk.
Yes.
Okay.
I'm waiting for, they said they would return my call and we may have missed each other. I didn't check my voicemail yet today. I was at work earlier.
All right. Call them back
Yes.
and tell them that you have a judgment, that your writ date is the 11th.
Okay.
Okay.
All right.
And funding's a little bit tricky right now, but
Right.
something may happen with that.
Okay.
And they may be able to point you in the direction of other resources and the like.
Certainly.
But certainly let the VA know that about that date. Okay? All right. Thank you.
Appreciate it.
Take care. Court does call the case of Arbor Woods versus Carroll, Toronto. And Judith Wells. Hello, what's your name?
I'm Carol Taranto.
Okay. And is Miss Wells here or no?
She is in the hospital.
Got it. Okay. So what do we have now as the current balance on?
Your Honor, we have rent retained of,
Go ahead.
sorry, Your Honor, we have rent retained of $3,409.44. Cost of $242.00 for a total of $3,651.44. And Your Honor, after further investigation, after the last hearing, we noticed that Judith's Zoom name said Welts instead of Wells. So we did some investigation and the correct spelling of her name, I believe, is Welts, W-E-L-T-S. W-E-L-T-S.
So it's Welts.
Yes, I believe so, Your Honor. So we're asking that we be allowed to amend that.
Man. Is that correct?
W-E-L-T-S.
W-E-L-T-S. Okay. Okay. All right. Okay, so with that amount, how,
So I just got out of the hospital myself. I will get, I don't have any sick time left, but I have short-term disability that I can apply for. So 2 of the 3 weeks I can get paid for. I'm not sure how long the process that will take. I'm sure it'll be a few weeks that it'll take to be able to get some of that process in. Then also I will have some money coming in on the 3rd through the Social Security check for my mother. But we do have bills that there are other bills though that have to be paid in the time
I
too.
understand. All right. And have you contacted Hawk?
I contacted Hawk. I was turned down with Hawk. I'm trying to I'm sorry, not Hawk, the SERS. Hawk is the next one that was on the list to do it. And if there were any other resources, like I said, I just got out of the hospital, so still trying to figure out, and that my daughter was helping because last hearing I was in the hospital, so trying to assist and get resources that we can find to, find additional funds.
All right.
Permission to speak, Your Honor.
Yes, who were you?
I'm Allison. I'm her oldest daughter. My sister Anna and I were trying to coordinate the resources. We were the granddaughters that spoke up with Judy in the last.
Then why didn't you just say something? Go ahead. No,
Sorry.
no. Now, when you said that, I recognize you now from the, okay, go ahead.
So I contacted Hawk, but because it was over $3,000 and they had to do an interview process, we were ineligible at the time since she was in the hospital, and then now Judy is in the hospital. I couldn't do the bridges because I couldn't get into her account without having like the 2 back. I had her log in, but they had the verification with her phone and that wasn't accessible. Working on doing a disability claim with outside of short-term disability for work, but currently filling out that paperwork as well. But it's just been a lot coordinating resources with in and out of the hospital. Like she said, she just got out on Monday evening. And so that's kind of where we are.
Okay, did, when you spoke with Hawk, they talked about you being over the $3,000 if they could help at all.
Yeah, they said it would be unlikely to be approved given the amount and the resources that were available, but they would need to do an interview process first with the tenants. So my mom and grandma, but they weren't available to do that. And so because they kind of seemed that it wouldn't be a possibility, I didn't move forward with that.
Okay, so let me ask you this. With if you had to come up with $651, let's say $652, when could that happen if it could happen?
Okay. On the 3rd for the Social Security.
I'm sorry, I'm just referring to, because they're kind of
it's okay.
helping taking over everything with trying to figure everything out.
On moving parts, Your Honor, but yes, on the 3rd with her short-term, or I'm sorry, the Social Security from my grandma Judy Waltz's Social Security.
So if you could come up with it, that would be when?
The date on the 3rd.
Okay. All right. I can't guarantee this will work, but I think this is going to give you the best shot that I can think of at this point. Is I'm going to find that there's no tribal issue after hearing this matter. I'm going to grant a judgment for possession to the plaintiff in that amount of the $3,651.44. All right. So that you understand, because that's kind of scary when I say that, right? I'm trying to, as best I can, freeze that number without July kicking in. Okay, so this doesn't include July. Okay, you've got that check coming in on the 3rd. What I'm going to suggest is you try to get back to Hawk, let them know that this is a judgment. Okay, and I'm going to make the writ date over the objection of plaintiff. I'm going to make it the 11th because they're trying to work everything they're trying, I know you guys are working hard, so I get it. And so and let them know that if they kind of flinch at that number and say they can't help, that you have that amount, that you can get that amount, all right? This is the best that I can think of at this point, but understand, how much is your monthly rent?
1544.
1544?
And then,
okay.
and then sewer and water too. May bring something else up at the moment too.
Pardon?
May bring something else up at the moment as well. Part of the rent increase too was there was a break in the sewage line, and the water and the sewage went from, it's usually between 30 for one and 60 for the other, so somewhere around between $90 and $105 for the month, went up to $428 because it was spewing through the cracked pipe underneath the trailer. And I had tried to contact to get like a part of that, reduced and taken care of, and site manager changes. And I never did get any information back. Also, they were supposed to come back up and clean up all of the sewage that had spewed.
Were those
under the
your
trailer.
pipes or theirs?
No, it's theirs. It's a rental.
Ooh.
I will say, Your Honor, we were visiting because I live in Maine, and we were visiting at the time, and it took them, it wasn't like an emergency situation for them. It took them a substantial number of days to come to the unit. So those amount of days of water flow from that area probably accumulated that large cost in terms of the service.
Council, do you see like an increase in water sewer charge along the lines that she's talking about?
Might have been April or May.
She's thinking it's April or May.
Your Honor,
Is it just one?
in April, the water charge was $198.75. And in April, the sewer charge was $132.53.
Okay. All right. Well, then it couldn't have been around then because that's about kind of where you said it was. Okay. All right. So here's what I'll do. I'm going to do it this way. All right. It's the best that I can think of. I'm going to make, like I said, the eviction date or the writ date 11. Just by way of full disclosure, I don't know what they'll do with it.
And I just wanted to bring it up and I did send emails and voicemails and that on, trying to get it corrected and taken care of and, get.
No, I got you. But here's what I was going to say was I'm trying to please that number. The reality of what may backfire in this whole thing, just to let you know, is that when they ask for the ledger, July is gonna click onto that ledger. And so while we're trying to get you at the $3,000 figure.
No, we can just leave that. I wasn't expecting, that wasn't like they were going to pay it to begin with. So I don't have a problem just not trying to address that further if that's.
Okay. All right. So let's just.
More trouble than it's worth to try to.
Gotcha. Okay. So we'll do it this way. Get in contact, and also Ms. Bauer, I don't know what funding might be available through Housing Bureau for seniors for this individual also.
I just whispered to this individual that they might want to contact. Unfortunately, Your Honor, I deal with the clients that have small children in the house. Those are the referral or the funding sources that I really.
No, I got you.
About. So SCIP is kind of a new thing that I became aware of. And I believe that Housing Bureau for Seniors is helping someone else that I'm connected with get that fund. That's what made me think of it today.
All right, very good. So we'll get you that information and maybe that'll help. I mean, and I by no means am implying that you would even qualify for Housing Bureau for seniors. I'm not gonna even say that, all right?
That's not,
Okay, all right, so we'll leave that where it is, okay?
okay,
You guys have a blessed weekend.
all right. And then do I need to ask next steps?
So I've done this, so
Right.
your next steps would be to get back in touch with Hawk.
Right,
And
yes.
also the information that they give regarding Housing Bureau for seniors.
Okay, but as far as court though,
No more.
no more court. Okay,
All right, thank you.
thank you. Thank you
Thank
so
you.
much.
Your Honor.
Oh. Okay, hold on.